5 parts. The first part already yesterday, Madam lightly touched upon it, and that's nothing but a preliminary topics and definitions. Part 2 is very much important. Yesterday we started with the part 2. In the part 2, we are having a corporate insolvency resolution process. That was almost section 6 to 32. Already yesterday, Madam discussed elaborately, and we are having 3 more topics in part 2. That is liquidation, fast track, and voluntary liquidation. These five areas are like CARP, liquidation, or fast track, or voluntary liquidation, which are comes under the corporate insolvency resolution process, which comes under the part 2 of the insolvency bankruptcy code. Now we are moving to part 3, where our Ritesh is talking about today. That is nothing but individuals and partnership firms. And in individuals and partnership firms also, we are having a 3. I think fresh start is one process, and insolvency of individuals is one process, and bankruptcy of individuals and partnership firms is one process. Almost in a part 3, if I am not wrong, more than 100 sections are there. And for the purpose of examination, each and every section is important. Coming to our practice area, because we have already promised to touch upon wherever is possible to help our practicing insolvency professionals. The personal guarantors is very much important. Already this is on the line. That's what I requested our today's speaker Ritesh Mittal to talk on both areas. So thank you so much, Ritesh, for helping me out and coming to here to share your knowledge. Thank you. Handing over to Secretary.
Thank you, Chairman, sir. May I now request Treasurer of the branch, C.A. Rajambal, to give the introduction for the speaker of the day.
Thank you, Deepak. A warm welcome to all the delegates and a very good evening to all of them. A special welcome to the speaker of the day, Ritesh Mittal, a very good friend for ages now, and a good spokesperson for the branch and go-to person in most of the cases, and very, very dear friend to most of us, like our chairman said. A warm welcome to the branch chairman, Machara sir. Warm welcome to Deepak, vice chairman, but acting as a secretary today. And IBC, IBC, like sir has said, is once again an enactment in itself. And we're very glad that we've got such a good lineup of the faculty members and such good 5-day refresher course. All the best to all the exam aspirants who've been considering passing it out now. Like, I think immediately after such a refresher course, it will be very easy to get through the examinations. Let me introduce the speaker for the day. Ritesh, although you need no introduction to Hyderabad audience, but I guess audience from out of Hyderabad are also there. So at least for their sake, I'll introduce you. Ritesh is a senior partner of Mrs. Sanjay Kumar Kothari and Company Chartered Accountants. He is graduate in commerce and law, chartered accountant, visa qualified, and also an insolvency professional. He expertises in the areas of company law, direct tax, indirect tax, legal matters for the last 15 years. He's been the IRP for companies like Thrive Solar Energy, Mark Infrastructure Private Limited, SNS Starch Limited, BRC Shoreline Enterprises. He's been a resolution advisor for various resolution applicants for preparation of resolution plans and allied documents. He represents before NCLT in the matters of IBC. He has held quite a few leadership roles and positions, including Managing Committee member of Federation of Telangana Chambers of Commerce for the term 2019 to 21, Chairman of GST and Customs Committee for the same organization 2021, Governing Council member of Telangana and Andhra Pradesh Tax Bar Association for the same term 19 to 21, and presently holding a position of secretary there. He is nominated member of the Regional Micro, Small and Medium Enterprises Facilitation Council, Medchal, Malkajgiri District, Regional Council member of SIRC for the term 2016 to 19, Managing Committee member of Hyderabad branch of SIRC of ICI in the term 2013 to 16. I'll not take much of your time and I present this vibrant speaker to all of you today. Welcome, Ritesh.
Thank you, Rajambal, for the introduction.
And small request, Ritesh, before that, sorry for interrupting you, because you are into the practice of insolvency from 2017. And to the best of my knowledge, one of the practitioners who handled very much different type of cases. And recently also we handled one of the different case, so that I request you to impose some practical experience of you to our insolvency professionals. Thank you. Thank you.
Thank you, Chairman Macharao and Vice Chairman Deepak. First of all, I'm very thankful that for the opportunity which is given to me. And IBC, way back in 2016, it has been introduced, the code. And now, in fact, it's like 4 years. Yes. So it has been effective. And still, if you see, though initially there were a lot of changes which were happening in the code, now more or less it has been streamlined. But yes, I see professionals who take up IBC under various forms. There are one set of professionals who are totally dedicated into IBC. So, like some example, like they have left the job and now they are in full-time IBC. So, right from the stage of IP or valuation or forensic, and as well as liquidation, they are there. They're providing services. Second stage of professionals are they parallelly take up the practice of CA profession and are doing the IB.
Deepak,
Yes.
voice is clear? Deepak, Ritesh, voice is clear? Ritesh, I think a little bit.
Yes, voice is clear. Voice is clear for me.
Clear?
Please
Yeah.
carry on. Please carry on.
Fair enough. So the thing is like IBC here and order. Yes, thank you. So the thing is like you have to be continuously updated on the subject. The reason is it's not that you have complied 99 points. Suppose 1 point if you don't comply. And as you all know, the regulator IBBI is very stringent. And when it comes to IP, there is no exceptions. You can say that when it comes to adjudicating authority, everything becomes recommendatory for them. But for a IP, everything is mandatory. 3 days for a public announcement means 3 days. It cannot become 4 days. Whereas for adjudicating authorities, 14 days can become any number of days. It becomes recommendatory. Sometimes, the reserve for orders doesn't come for months together. No one can ask them. But once it comes to IP, there is no mercy shown from the IBBI's perspective. So in such a situation, and when the code is regularly changing, we as insolvency professionals have to regularly update. Okay. So for example, like I'll just tell you, as we have the authorization for assignment, we were discussing on the WhatsApp group also. This authorization for assignment was introduced in the code in the month of July 2019. So it is basically in lines with what we say as a COP for a professionals. What it says is insolvency professionals have to apply for the authorization for assignment every year. And at the time of renewal, around 45 days before when he applies for renewal, at that time the regulator checks whether in the entire year he has complied to all the provisions of the code regulations, all the compliances of filing has been done, the fees, everything is paid, and the compliance of CPE credit is also done. As you all know that the CPE is also mandatory for insolvency professional from 1st of January 2020. So they will also check the CPE requirement. If the entire compliance is done, only then the authorization for assignment is renewed. Else, what will happen? It is something like, the COP of a CA is valid for 1 year. And the next year when he has to e-check whether he has made all the compliances, only then again the COP will be issued. This is how to check the provisions of CA Act with the IBBI. So the compliances are very rigid, and every work of an IP parallelly he needs to keep up the filing to be done on the IBBI portal, right from the stage of issuance of a form 2, then taking up the assignment, and then each stages. Now recently a new form has also been introduced to CRP 7, wherein if the interim resolution professional or the resolution professional is stuck at some place. Where he has stuck, what is the reason and what is the status? That is all. Because earlier form CRP 1 to 6 were showing the stage of progress. At each stage of work, it was showing what he is doing. But suppose he gets stuck, there was no such form. So this one form has been introduced recently last month, CRP 7, wherein it says if the IP gets stuck at some place, he has to say which place and what place he is stuck. For example, if he is stuck at constitution of COC, or if he is stuck at the issue of information expression of interest, or at any other parallel stages, he has to say what is the reason why he is stuck, and all those documents has to be uploaded. And suppose tomorrow, if you don't upload, again the consequences are again there. For example, he would say that no, the authorization for assignment cannot be renewed. So that's what happened. Like last year, around 25 to 30 IPs. They, without a valid authorization for assignment, they took up the assignments of IRP, RP, or liquidator. Subject, and immediately within around 1 month, they had to face the disciplinary, and that's how the list was there in the IBBI website. Now coming to my presentation, I'll just share the screen.
Ritesh, can you little bit near to the system?
Yes.
Voice still is a little bit low. Some people are asking.
Okay.
That. Yeah, now okay, sir.
Enough. Yes.
Done.
So Insolvency and Bankruptcy Code Part 3, Individuals and Partnerships. So as Machara has said, in the framework of IBC, there are totally 5 parts. Which starts from part 1, which talks about preliminary, various sections from 1 to 3. So whatever sections which are there under 1 to 3 is applicable for the entire act, entire code. Then we have part 2, IRP and liquidation for corporate persons. Okay, corporate insolvency resolution process. Then we have part 3, which is for individuals and partnerships. And then we have part 4, various regulations are there here for IPs, IPAs, IUs, IPEs, valuers, all these regulations are there in part 4, and part 5, which is miscellaneous. So now here, if we see the arrangement of sections, part 1, 2, 3, and 4. Okay, so yesterday what was discussed was part 1 and part 2, preliminary corporate insolvency resolution process, liquidation, fast track process, voluntary liquidation, adjudicating authority, offenses and penalties. Is it the only structure there, or something else is also there? So this is the only code. Apart from the code, we have regulations. What are these regulations? For example, when you study income tax, along with the income tax, what we study is income tax rules. When we study GST, along with the CGST, SGST Act, we also go through the GST rules. Now there is only one set of rules in income tax, one set of rules in GST. But when it comes to Companies Act, for each chapter there is a separate rule. Similarly here, instead of calling them rules, they are called as regulations. So they are regulations majorly associated for various chapters. For example, CRP, there is a separate regulation. Liquidation, there is a separate regulation. Fast track, voluntary liquidation, there is a separate regulation. Fast track CRP, there is a separate regulations. Then there is something called as rule also. Rule comes when there is an application for adjudicating authority. So in case if you have seen yesterday, there was only one rule, application for adjudicating authority rules. Okay, those are the rules associated with section 7, 9, and 10, where an application is made to the adjudicating authority for initiation of CRP. For that set of rules is there under application to adjudicating authority rules. That is the only one rule which is there for when an application is made to the adjudicating authority. All others are called as regulations. Similarly, now in part 2, which we will discuss today, insolvency resolution and bankruptcy for individuals and partnership firms. Preliminary, fresh start process, insolvency resolution process, bankruptcy order, administration and distribution of an estate, adjudicating authority for individuals and partnership firms, offenses and penalties. Okay, this is what we'll be covering, total 110 sections, along with the rules and regulations. What are the rules here? Again, as you all know, though the individuals and partnerships has not been notified, the provisions for personal guarantors to the corporate debtors has been notified. So suppose I have given a personal guarantee on behalf of the company, then in that case, I can be taken into the part 3 of the IBC, which is under individuals and partnerships. So for those things, it has been notified for personal guarantors. Then we have the part 4, which talks about regulations. For various regulations are discussed here. So those are the IBPI regulations, board, IPA regulations, IP regulations, information utility, inspection investigations, accounts. So here you will see the maximum regulations will be there for each. In fact, each set of sections you will find various regulations, more or less. So here they, in this part 4 will have maximum regulations, and then you have the miscellaneous chapters, which takes which says in the case of conflict which act will prevail, all those are there in the, and we have totally 11 schedules which amends various acts. So through these schedules other acts have been amended, so those are there under schedules. So this is the total gambit of the insolvency and bankruptcy code. So here when it comes to the code, each and every line of the code is important for examination perspective, as well as for practice purpose also. Most of them are important, except those the sections you can say that where they have not been notified, you can say it's, but otherwise every section of the code is important. Okay, and one thing is when it comes to IBC, most of the questions, if you see, unlike valuation where other topics are more, here in IBC around 70% of the marks are from the code, whether it can be case laws, case studies, okay, or the straight answers from the code. So if you are thorough with the code, 70% of the syllabus is covered, 70% of the marks are covered. So in such cases, you cannot afford to miss even a single line of the code, rules, regulations, schedules. So each and every line becomes important, and you will find questions from all areas. There will not be any question which varies, not any chapter which is left over. Across all the chapters, questions will be asked. So coming to the individuals and partnerships, we have 7 chapters under part 3. So preliminary, chapter 2, fresh start process, insolvency resolution process, bankruptcy order for individuals and partnership firms, administration and distribution of the estate of the bankrupt, adjudicating authority for individuals and partnership firms, offenses and penalties. These are the various chapters. So these are the key milestones. In May 2016, IBC was enacted, CRP was commenced in December 2016, and for individual personal guarantors was being notified on December 2019. So now section 2 of the code, which says here what has happened is this was notified 2E, personal guarantors for corporate debtors, was notified in December 2019. So the provisions of the code, the provisions of the code shall apply to any apply to any company governed by the special act, limited liability partnerships, such other body corporate personal guarantors, partnership firms, individuals other than persons referred to under clause C in relation to the insolvency, liquidation, voluntary liquidation, or bankruptcy, as the case may be. So now coming to the insolvency resolution bankruptcy for individuals and partnership firms, effective from 1st day of December 2019, we have the 4 regulations which have been introduced for personal guarantors. The insolvency and bankruptcy, application to adjudicating authority for insolvency resolution process for personal guarantors to corporate debtors, rules 2019. Insolvency and bankruptcy, application to adjudicating authority for bankruptcy process for personal guarantors to corporate debtor, rule 2019. IBPI, insolvency resolution process to personal guarantors to corporate debtor, rule 2019. IBPI, bankruptcy process for personal guarantors to corporate debtors, regulations 2019. So along with the code, we have 2 set of rules and 2 set of regulations which has to be covered. Now, why are we having two set of rules? If you see in CARP, there was only one set of rules, which was application to adjudicating authority. So what was happening there is, if CRP was invoked under section 7, 9 or 10, okay, section 7 was for financial data, section 9 for operational data, and section 10 by the data, corporate data himself. If CRP was invoked, initial stage will be CRP process, and if the CRP fails, automatically triggers liquidation. So there was only one set of rules for invocation of CRP. But here, when it comes to individuals and partnerships, initially, if you want to take a individual or partnership to CRP, you have to go with the application to adjudicating authority for IRP, insolvency resolution process. Insolvency resolution process, okay. So, okay, we'll not say IRP because IRP generally is taken for interim resolution provision. So, okay, I'll say insolvency resolution process for personal guarantors. Then subsequently, if suppose that process fails and it goes into bankruptcy, it is similar like liquidation. It is called as bankruptcy. In that case, again, it has to be applied to the adjudicating authority. Okay, in the set of rules called as applicating the adjudicating authority for bankruptcy process for personal guarantors. Okay, now similarly, we had there the CRP regulations. So here also we have the insolvency resolution process for personal guarantors regulations, and the second set of regulation is for bankruptcy process. So two set of rules for applying for adjudicating authority. So first stage will be application for adjudicating authority. Once application for adjudicating authority is accepted, we have to go with the rules of insolvency resolution process for personal guarantor. Then if that process fails, then again it has to be applied for adjudicating authority for bankruptcy process. Okay, and then if that is accepted, we have to go with the in bankruptcy process for personal guarantors regulations along with the code. This is how in the nutshell it is. So now this is the chart here. Okay, so here what it says is, here if you see the insolvency and bankruptcy code for corporates and non-corporates. For corporates, the minimum amount which was notified was 1 lakh, which can be increased to 1 crore. On 21st of March 2020, this amount was increased to rupees 1 crore. Okay, and whereas for the non-corporates, the minimum amount of default is 1,000. Okay, which can go up to 1 lakh. Now, in CIRP process, there are two stages: corporate insolvency resolution process stage, and the second stage is liquidation stage. Okay, and for the application for CIRP has to be initiated by the adjudicating authority. The first adjudicating authority is NCLT. Once NCLT adjudicates the CIRP process, and if the CIRP fails, automatically it goes into liquidation. Next, the next appellate authority is NCLAT, so National Company Law Appellate Tribunal, or NCLAT. That is the next appellate authority, and then the apex court is Supreme Court. So it is basically NCLT, NCLAT, and straightaway Supreme Court when it comes to corporates under Part 2. When it comes to non-corporates, we have individuals and partnerships. For individuals, again, if they are personal guarantors to the corporate debtor, the individual, the insolvency resolution and the bankruptcy, this will be governed by the NCLT in the same corporate person where they have given the guarantee. So it will follow the same tribunal where the company CIRP process has been initiated, because the CIRP jurisdiction goes with the registered office of the company. So if the registered office of the company is Hyderabad, then it will go to NCLT Hyderabad bench. Similarly, there is a personal guarantor to the corporate debtor. His individual personal guarantor case will also be filed with the NCLT Hyderabad. So this is with respect to the personal guarantors to corporate debtor. The jurisdiction will follow the corporate debtor's jurisdiction, and it will go to the same NCLT. Other than personal guarantors, along with the partnership firms, again, these two stages, insolvency resolution stage and the bankruptcy stage, the adjudicating authority is DRT, Debt Recovery Tribunal, and the next appellate authority is Debt Recovery appellate tribunal, and the apex authority is the Supreme Court. So now, in this case, to the extent of the personal guarantors to corporate debtors has been notified. The other than personal guarantors and the partnership firms have not been notified. This is the situation. Now, chapter 1, preliminary. We have a couple of definitions which has to be covered here. Section 79, subsection 19, qualifying debt. Qualifying debt means amount due which includes interest or any other such sum due in respect of the amounts owned under any contract by the debtor for the liquidated sum, either immediately or at a certain future date, but does not exclude. Okay, so that means what is a qualifying debt? First of all, qualifying debts are those debts which can be taken over by the resolution professional or the bankruptcy trustee. Okay, those are the debts which he will take over. They are qualifying debts. So that means what are debts? Which includes interest and other sums in respect of the amount owned under any contract by a debtor for a liquidated sum. Liquidated sum is any sum where you can substantiate the value which can be liquidated sum, either immediately or at a certain time period, but does not exclude excluded assets. So qualifying debt does not exclude excluded debt. What is the excluded debt? We will see on the next slide. There are a list of items which will not be covered under the excluded debt. A debt to the extent it is secured. So here this is very different from the CRP process. In CRP, if you have seen yesterday, the majority or you can say the COC is constituted by financial creditors. There the creditor was segregated into financial creditors and operational creditors. Financial creditors are part of COC members. Unless until there are no financial creditors, then 18 operational creditors plus one will be there. But in general, the COC will be constituted by financial creditors. Financial creditors can be secured creditors, they can be unsecured creditors. But here, if you see, a secured creditor is totally outside the qualifying debt to the extent it is secured. So suppose if there is a bank, okay, which has the assets of the, you can say, the personal guarantor or has taken as a collateral. His personal property has been taken as a collateral. In that extent, to the extent it is secured, that will be outside the qualifying debt. For example, if the loan amount is 50 lakhs and the debt amount is 40 lakhs. So in this case, the secured amount is 40 lakhs and the unsecured amount is 10 lakhs. So to the extent it is secured, it is outside qualifying debt. Okay. What will remain here is only to the extent of unsecured debt. So this is very much unlike the CRP process where all secured and unsecured creditors were forming part of CRP or the committee of creditors. Only in the extent of liquidation, the question was arising whether the creditor is relinquishing his right or not. But in the stage of CRP, they were all part of the committee of creditors. But here, the qualifying debt is only for unsecured portion. Secured portion does not included in the qualifying debt because anyway the banker is going to take away the asset. So to the extent of debt, the RP is not going to consider. Then coming to third part, a debt which has been incurred 3 months prior to the date of application for fresh start process. So I'll come to fresh start process. If you see the part 1 definition 78 and 79 is applicable for all the 7 chapters. Okay, but there is one chapter part 2 fresh start process. So this part C is only applicable for fresh start process. This part C is not applicable for other chapters. So it says a debt which has been incurred 3 months to the date of application for fresh start process, a very newly freshly created debt. I knew that I'm going to enter into a fresh start process. So what I have done is just 2 months before or within 3 months, I have taken a loan, okay, for this amount. So that debt which was taken immediately 3 months prior to the date of fresh start process will also not be included in the qualifying debt. Now coming for We have seen qualifying debt does not include excluded debt. What is excluded debt? Excluded debt means which cannot be taken over by the resolution professional, which has to be paid, by the debtor. What are those debts? Liability to pay fine imposed by the court or tribunal. There is a fine which is imposed by the court or tribunal. I wanted to get into bankruptcy or individual insolvency resolution process. Can I settle it? Not possible. This is a excluded debt. Liability to pay damages for negligence, nuisance, or breach of statutory, contractual, or other legal obligations. Again, it will be an excluded debt. So, liability to pay damages for negligence, nuisance, or breach of statutory, contractual, or other legal obligations. It is also excluded debt. Liability to pay maintenance to any person, under any law for the time being in force. Suppose a person is supposed to pay maintenance to his or her spouse or his parents, and then he wants to avoid the liability of paying the maintenance, and he says, I will get into part 3 of the insolvency, I'll go bankrupt and I will be excluded from this debt. Not possible. Okay, because it is a excluded debt. Liability in relation to a student loan. Now, what happens is here, suppose I get into the best MBA colleges. I've gone into okay, and then I've taken a loan for around 40 lakhs. Okay, then I have done my course, and subsequently after doing the course, there is a huge amount which has to be repaid, because now if you see, the courses are very expensive. And then the student says, what if I become bankrupt? Can I avoid paying the student loan? Not possible. Liability in relation to a student loan is forming part of excluded debt. Any other debt which may be prescribed. So these are the debts which are excluded. So always a creditor would be happy if his debt are included in the excluded debt. Because if it is a part of the excluded debt, compulsorily the creditor or the debtor is supposed to pay the amount. He cannot avoid the excluded debt. So always a creditor would like to ensure that his debts are forming part of the excluded debt, and as far as possible, he wants his amounts to go out of the qualifying debt and get into excluded debt, because qualifying debts will be taken over by the resolution professional or the bankruptcy trustee, and based on the amounts which is going to be repaid, the amounts will be repaid. In some cases, they might not get any amount also. So that is the case. So qualifying debts are those debts which includes interest and other sums in respect of the amount owned under any contract by the debtor for a liquidated sum immediately or at a future time, but does not include excluded debts. Debts to the extent it is secured, and certain debts which has been taken 3 months before the fresh start process. And we have seen the 4 types of excluded debts. Now we have the next category called as excluded assets. Now what he will try to do is, a resolution professional will take all the qualifying debts and he will take all the assets and try to get the money from the assets and pay the debts. Which debts? Qualifying debts. Now in taking over the assets, there are certain assets which will be excluded. What are those assets? For the purpose of this part, excluded assets includes unencumbered tools, books, vehicles, and other equipment as are necessary for the debtor or the bankruptcy for his personal use or for the purpose of his employment, business, or vocation. So these are tools, vehicles, and other equipment. Now, what are these? Suppose for a specific, karigar, he needs certain set of equipments to which he does his job. Those will come in this category. Okay. For example, a chartered accountant, you can say books are the specific, tools books. So a chartered accountant books come down here, and for every technical person, what are the tools which he is using to get his work done will come in the excluded assets. So these assets cannot be taken over by the IP. Next, coming to unencumbered furniture. What is unencumbered? Unencumbered means which has no lien, Because once the lien is there, it goes under secured. Secured means what happens once it is secured, it will be outside the qualifying debt. So all unencumbered furniture, household equipment and provisions as are necessary to satisfy the basic domestic needs of the bankrupt and his immediate family. So furniture, household equipment and provisions coming here basically. Then coming to any unencumbered personal ornaments of such value as may be prescribed of the debtor or his immediate family, which cannot be parted with in accordance with the religious usage. So if the debtor spouse is having some Sridhan, Mangal Sutra, all those items will come under unencumbered personal items in accordance with religious usage. Then coming to next item, unencumbered life insurance policy or pension plan taken in the name of the debtor or his immediate family. And the last one, an unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. One single dwelling unit owned by the debtor for such value as may be prescribed. Then coming to this one. Then coming to application for adjudicating authority for insolvency resolution process for personal guarantors to corporate debtor. Now here we have seen certain personal ornaments of such value as may be prescribed. Okay, single dwelling unit of such value as may be prescribed. What is the amount of value? So the value of unencumbered personal ornaments shall not exceed 1 lakh. So if some ornament is more than 1 lakh, then it will come part of the included asset and it will not be an excluded asset. Then unencumbered single dwelling unit. So it should be one house, and that one house value should also not exceed, in the case of the urban areas, 20 lakh rupees. In the case of rural areas, 10 lakh rupees. So if that one house which is less than 20 lakh rupees will come part of the excluded asset, and if it is an urban area, its value should be 10 lakh rupees, it will be called as a excluded asset. So these assets are to ensure that the basic minimum requirement of the person to live can be met. So that is how these 5 assets are forming part of the excluded assets. Then associate of the corporate debtor means, so subsequently we'll come across various places where it will say the associated of the corporate debtor should not be part of the the persons who are voting in the creditors list. So who is an associate? So associate, it is in lines with what we have seen in the CIRP process, a relative. So here, who is an associate? A person who belongs to the immediate family of the debtor. So family member, a person who is a relative of the debtor or relative of the spouse. What is the relative is given in the explanation. Then a person who is in partnership with the debtor, so his partner. A person who is a spouse or a relative of any person with whom the debtor is in partnership. A person who is employer or employee of the debtor. A person who is a trustee of a trust. Okay. And last one, a company where the debtor or the debtor along with his associates own more than 50% of the share capital of the company or control the appointment of the board of directors. Now, there is an explanation for the purpose of this subsection. Relative with reference to any person means anyone who is related to another. If they are members of the same HUF, a person is related in such other manner as may be prescribed. Okay. Now, coming to the part 3, which is individuals and partnerships, coming to section 78, application. This part shall apply to matters relating to fresh start, insolvency and bankruptcy of partnerships, where the amount of default is 1,000 rupees, is less than rupees 1,000, provided the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 lakh rupees. So here, if you see the part 3, it is under 2 parts. It is fresh start process. So fresh start is a separate process which is given here, and individuals and partnerships, insolvency and bankruptcy, where the amount of default is less than rupees 1,000. Okay. where the amount of default is not less than this. It is more than rupees 1,000 and which can increase up to 1 lakh. Okay, this was in similar line to CRP where the amount of default should be more than 1 lakh and can be up to 1 and subsequently this limit can be increased up to has now been increased to 1 crore. So here the amount of default should be more than 1,000, which most of the cases it will be there. Now coming to the notification for individuals and partnerships with respect to personal guarantors to a corporate debtor. Now, who is a personal guarantor? Suppose a company has taken a loan and I as an individual have given the guarantee. So I become the personal guarantor to the corporate debtor. What it is vice versa? Suppose company is a guarantor and I have taken the loan. Okay. Now, so in such cases, can the creditor proceed against the company under CRP? Yes. Okay. So if the company is a personal guarantor, straight away you can take the company to CRP process. But when the individuals or partnerships is a personal guarantor to a company, in that case, the individuals and partnerships, they will come under part 3 and they will go, their jurisdiction will go with the company. So these are the set of sections, as I've said initially. Section 2 clause E talks about the provisions of the code applicable for personal guarantor. Section 78 and 79 is for the insolvency resolution process, and it says except with regard to fresh start process. So fresh start process provisions are not yet notified. 98 to 187 are the all set of sections in this part 3, and we have various powers to make rules, regulations. Those sections are there, 239 to 40. Those have been included here. Now coming to part 3, there are chapter 3 and chapter 4. This is in line with CRP, wherein there are, I would say, the CRP process is like in stages. First stage is for the interim resolution professional stage, which goes for around 30 days. Then the resolution professional stage, and then the bankruptcy stage. Here, there are 2 stages: insolvency resolution process and the bankruptcy process. So each stage in CRP, what we used to do is only once we used to file the application for adjudicating authority. Once CRP is triggered either under section 7, 9 or 10, then straight away it goes to CRP, and if the CRP fails, it goes to liquidation. The trigger of liquidation was automatic, whereas here liquidation is called as bankruptcy. So trigger for bankruptcy is not automatic. You have to make an application for adjudicating authority for insolvency resolution process, and subsequently if that fails, again you have to make an application for the bankruptcy process. So parallelly we have, so these are the 2 set of rules for application for adjudicating authority, 2 set of rules, and there are again regulations how the process will be dealt. So we have to read the code along with the rule for application for adjudicating authority and the regulations for 2 parts, that is insolvency resolution process and the bankruptcy process. So that is how it is. Like part 1 is preliminary, part 2 is fresh start process. Fresh start process is altogether a different process. Okay, so fresh start process, though you have seen the qualifying as excluded assets of such amount, here you will see altogether a different set of amounts. Then, so actually part 3 and chapter 3 and chapter 4 are the insolvency resolution process and bankruptcy resolution process. Fresh start is altogether a different process. Next chapter is fresh start. I'll cover that, how different it is and why it is different. I'll cover there. So basically, as we have seen that CRP, here it is called as insolvency resolution process. As we have seen that liquidation, here it is called as the bankruptcy order. Then administration and distribution of the asset of the bankrupt. In CRP, there was only 1 chapter, liquidation. Here, the bankruptcy order is broken into 2 chapters, chapter 4 and chapter 5. Bankruptcy order for individuals and how the bankruptcy trustee is going to administer the assets. How is he going to distribute the amounts? How is he going to recover the amounts? Those sections are put under chapter 5. Overall, chapter 4 and chapter 5 talks about bankruptcy. Then we have chapter 6, which talks about adjudicating authority for individuals and partnerships. DRT, DRAT, which will be included here, and the Chapter 7 offences and penalties. Now we'll start with the fresh start process. So here, what I understand is, out of the participants, some of the participants are writing the limited insolvency exam, and some of the participants are already IPs. So for the benefit, now this fresh start process, though you can say it has not been notified for the IPs, okay, you might say it is not much important, but for the examination perspective, it is important. So section 80 to 93, what is the problem in the examination? The problem in the examination is the code is very simple. 255 sections. We have studied, various acts, income tax, GST, Companies Act. When compared to the GST Act and the Income Tax Act, the IBC code is very simple because the terminology is simple. Sometimes you start with income tax, it talks about various provisions, and subsequently it comes with the lines of so and so here onwards. This section has been omitted. There is nothing like that. The English is very normal, and in one plain reading, you can understand the subject. Now, where is the difficulty? The difficulty is not in understanding the subject. The difficulty is remembering the various dates which are coming in the subject. So one part of this, we can remember the subject as a story, but when it comes to the dates, the difficulty is rising. So there are various approaches wherein people remember the process of remembering the dates. What I have done here is, in the BEAR Act, there is something called as the index of sections. So for example, for straight of process, you will find the BEAR Act will be in this slide. From 80 to 93, you will see the index of sections. After the section, there will be a small gap. It will not be a huge gap. There will be a small gap. In that, I used to write certain numbers and codes. How those numbers and codes will come, that I will show in the due course of presentation. Okay, so this is how the sections will be there. So your BEAR Act should be in such a way that it should have an index of sections, not just for the code. It should have the index for the regulations and the rules also. Sometimes what happens is the BEAR Act has the rules and regulations, but it doesn't have the index for the rules and regulations. So you can check that. As far as I know, commercials have the index for rules and regulations. If it's not there, you can just have one, your own index and put it in the BEAR Act. So now, for example, this is the sections which we have to cover from 80 to 93. Fresh start process conditions. Now, these are the conditions which should be satisfied for the fresh start process. The gross annual income of the debtor does not exceed ₹60,000. So the gross annual income. So I have given the short words GAI, gross annual income. So I have written on the top GAI 60K. The aggregate value of the assets of the debtor does not exceed 20K. So AA 20K. The aggregate value of the qualifying debt does not exceed 35,000. So on the top, QD 35K. He is not an undischarged bankrupt, NUB. He does not own a dwelling unit, irrespective of whether it is encumbered or not. So he should not have any dwelling unit. No dwelling unit, NDU. A fresh start process, insolvency resolution process, or a bankruptcy process is not subsisting against him. So no existing fresh start process, insolvency resolution process are subsisting. No previous fresh start order on this chapter has been made in relation to him in the preceding 12 months of the date of application for fresh start. So no fresh start process in the preceding 12 months. So NFSP 12 months. Okay. So now these are the 1, 2, 3, 4, 5, 6, 7 conditions for a fresh start process. So if you understand for whom the fresh start process is applicable, are there persons having larger amount of loans or smaller amount of loans? They are for the people whom very small amount of loans is applicable. So the gross income, so the income is less than 60,000. So monthly around 5,000 should be the income there should be in bracket. Assets is totally 20,000. Qualifying debt is 35,000. So the total amount of debt the IP will be taking over is 35,000. So that means fresh start process is for small. I would say this can be for farmers or people going for mudra loans. So this and it might happen that the fresh start process might go for applications in bunches. They might be around, the IP might become a IRP for 100, on behalf of a banker or some authority, wherein he takes over the 100 or 200, 300 fresh start process conditions. That is how we'll file in bunches, because I don't see any scope wherein he will take over one case of fresh start process to where the qualifying debt is 35,000, amount of assets is 20,000, gross income. So this might take up, he might take up in, number of applications might be more. So that might be the scenario I can see. So eligibility for making an application: a debtor who is unable to pay debts and fulfills the conditions specified in subsection 2. So what are those conditions? These are the conditions. Okay. So now here you might have a doubt. You have seen one conditions which says he should have a single dwelling house up to 20 lakhs in urban areas and up to 10 lakhs in rural areas. But here you are saying he should not have a dwelling unit. What is it? So that is what I have said. See, initially we started with these three definitions: excluded debt, excluded assets, and qualifying debt, excluded debt, and excluded assets. These three sections are applicable for the entire part 3, whereas a fresh start process is a very small section or part of it. So that means when you are saying he excluded assets can include a single dwelling unit, unencumbered single dwelling unit, whereas fresh start process is a subset, because these three definitions are applicable for all the parts. So fresh start process is a subset wherein it is applicable to even more smaller criteria of loans. And one of the condition is they should not have any house. So that means these three conditions are applicable to the fresh start process along with the conditions which are there in the fresh start process. So if you apply fresh start process, what will happen? There, the single dwelling unit should not be there. So we have to apply these conditions along with the fresh start process conditions. Because if you say he has a single house, then obviously he cannot go into fresh start process. Okay, so he is unable to pay the debts, that is first condition, and fulfills the condition specified in the subsection 2. So these are the 7 conditions. Okay, of his qualifying debts. So these are all qualifying debts. What are the excluded debts? Excluded debts are other than what have been noted there: secured debts and debt which is taken just 3 months before the fresh start process. They are all excluded debts. So apart from the excluded debt, you can take all the qualifying debt. How should he apply? He can apply either personally or through a resolution professional for a fresh start under this chapter in respect of the qualifying debt to the adjudicating authority. So he can apply for a fresh start through himself or through the resolution professional. So application for fresh start: when an application for fresh start is filed, an interim moratorium shall commence on the date of filing the said application in the case of all debts. So though here if you see, only the debts which you are taking over are qualifying debts, but whereas here the interim moratorium is applicable for all debts, including secured debts and including the excluded debts. The moratorium is applicable because it says in relation to all the debts and shall cease to have effect on the date of admission or rejection of such application as the case may be. So here, this is something new which we are seeing here. There was no interim moratorium concept when it comes to CRP. There was something straight away moratorium. Once the CRP was initiated, moratorium is invoked. So this moratorium is invoked and this will continue till the CRP exists. But here, it was nowhere the case that when a person was applying for initiation of CRP under section 7, immediately after applying of CRP, there was no interim moratorium in part 2. Whereas here, as soon as he applies for the fresh start process, interim moratorium is applicable. First of all, what is moratorium? Moratorium is a calm period. In fact, that is the period where no person can, or all the existing cases which are against the debtor will be stayed, and he will the creditor cannot file any fresh cases against the debtor. Why is it required? See, when a resolution professional is coming in and he's taking over charge, he needs peace of mind. So suppose if there are multiple cases going across various places and various people are behind him, then how can he come with a resolution? So for that purpose, a moratorium is invoked. Here, in a debtor, in the individual and partnership firms, because the pressure is more, pressure from multiple people are more. So here the benefit is given right from the stage of filing the application itself. That is called as interim moratorium, and this interim moratorium will continue from the date of filing the application till the order is accepted or rejected, because anyway from there moratorium starts. So it is the additional layer of moratorium which is given from the date of filing the application till the date of acceptance or rejection of application. That is interim moratorium. Then during the interim moratorium period, any legal action or legal proceedings pending in respect of his debt shall be deemed to have been stayed. So any pending legal actions or legal proceedings pending shall be stayed. No creditor shall initiate any legal action or proceedings in respect of such debt. So all existing legal actions, legal proceedings will be stayed, and no creditor shall initiate any legal action or proceedings. So no fresh legal action or proceedings can start, and all the existing legal action and proceedings will be stayed. So existing as well as fresh, everything will stop. The application under section 80 shall be in such form and such manner as may be accompanied by fees as may be prescribed. So what is it referring? It is referring to the rules, because this is application for fresh start. So you have to go with the rules. As this fresh start process is not notified as on date, we don't have any rules here. Then the application shall contain the following information supported by the affidavit, namely the list of all debts. So all debts is given as AD owned by the debtor as on the date of the said application, along with the details relating to the amount of each debt, interest payable thereon, and the names of the creditors to whom each debt is owed. So he has to give the list of supporting documents as an affidavit, the list of all debts, okay, applications along with the amount of each debt, interest payable, and the names of the creditors. How much of interest is payable and the rate at which the stipulated in the contract. List of securities which he has given, the financial information of the debtor and the immediate family for up to 2 years prior to the date of application, the particulars of the debtor's personal details as may be prescribed. So these are the additional details which has to be given along with the affidavit, along with the application for fresh start process. Then the reason for making the applications. Why are you making the application? The particulars of any legal proceedings. LP is legal proceedings. So again, the last but one heading LP. The particulars of legal proceedings which to the debtor's knowledge has been commenced against him. The confirmation that no fresh start process order under this chapter has been made in respect of the qualifying debt of the debtor in the preceding 12 months as on the date of application. So no previous fresh start process for the last 12 months. So these all details has to be given along with the application form supported by a affidavit. The appointment of a RP. So debtor files an application through a resolution professional. As I've said, in this case, the application can be filed by the debtor himself or can be filed through a resolution professional. So where the debtor files the application through a resolution professional, where the amount under section application under section 80 is filed by the debtor through ARP, the adjudicating authority shall direct the board within 7 days on the date of receipt of the application and shall seek confirmation from the board that there is no disciplinary proceedings against the RP who has submitted such application. So because already the name of the RP is already there, through him the form has been submitted. So the adjudicating authority would want to appoint the RP who has initiated the application. So they will check with the board within 7 days that there is no disciplinary proceedings against the person. The board, once they get the application, communication from the adjudicating authority, shall confirm the appointment of the RP who has filed the application or reject the appointment who has filed the application and nominate another resolution professional suitable for fresh start. The board shall nominate the RP within 10 days of receiving the direction issued by A. So that means one application which is received through IRP, the adjudicating authority will check with the board within 7 days that this person of this RP doesn't have any disciplinary proceedings pending. Then the board has to confirm that there is no disciplinary pendings, or if they are rejecting it, they have to nominate another RP, and this has to be done within 10 days. So the time is 7-10. So if you remember, appointment of RP 7-10, 7 days given to the adjudicating authority and 10 days given to the board. Now this 7-10 will come for multiple sections in this chapter, because various stages are there where the appointment of RP will happen or the reappointment of RP will happen. So here, if you see 7-10, if you remember each section, that will be coming as 7-10. So this will help you in remembering other sections also. So straight away appointment of RP, if you remember 7-10, will help you. What if the debtor files an application himself? Nothing doing. The adjudicating authority will write to the board asking for resolution professional, nominating them to for resolution professional. Board will give them, nominate a person's name within how many days? Adjudicating authority 7 days, board within 10 days. That's it. That is how it is. So a resolution professional appointed by the adjudicating authority shall be provided a copy of the applicant. In both the cases, whether it is filed through the resolution professional or through the applicant himself, the copy of the adjudicating authority will be given to the resolution professional for a fresh start. So once he gets the resolution professional, he is appointed. Basically, he gets a copy. That means he is taking over charge. What should he do? Once he gets, then he shall examine the application of the resolution professional. The resolution professional shall examine the application made under Section 80 within 10 days of his appointment and submit a report to the adjudicating authority, either recommending, accepting, or rejection of the application. So this is examination. So what? Okay. So once an application for fresh start process is given under Section 80, the adjudicating, the resolution professional shall examine the application. Now, again, this is a very unique feature which is here. What the adjudicating authority has done is, it has delegated some part of its job to the resolution professional. Resolution professional, as soon as he is appointed, he is first given the job of examining the application, and he gives his recommendations whether to accept or reject the application. So that means some part of the work, because when in CRP under Section 7, 9, and 10, the RP only nominates. Whereas it is under Section 7, it is mandatory to propose the name of the IRP. Whereas Section 9, it is optional. But the role of the IRP will come only if CRP is initiated under CRP. Whereas here, as soon as the application is filed and it is accepted, the first job, even though it is not accepted by the adjudicating authority, the resolution professional examines the application. Okay, the report shall contain the details of the amounts mentioned in the application, which, in the opinion of the RP, are qualifying debt and liabilities for eligible for discharge. So he gives, along with the report, what are the qualifying debts? Qualifying are the debts which can be taken over, okay, or which can be discharged, and liabilities eligible for discharge. Okay, then the RP may call for such other information or explanation in connection with the application as may be required from the debtor or any person who, in the option of the RP, may provide such information. So he may call for additional information. Once he calls for information, the debtor has to give that information. So that's what it says. The debtor or any other person, as the case may be, shall furnish such information or explanation within 7 days from the receipt of the request. The RP shall presume that the debtor is unable to pay the debts at the date of application if, in his opinion, the information supplied in the application indicates that the debtor is unable to pay the debts and he has no reason to believe that the information supplied is incorrect or incomplete. So he sees that the information supplied is complete and the debtor is unable to pay the debts and he has no reason to believe that the information supplied is incorrect. The second case, he has a reason to believe that there is no change in the financial circumstances of the debtor since the date of application enabling the debtor to pay the debts. So though at the stage of filing the application, okay, there were circumstances, but subsequently during the process, if he sees that there is a change in the financial circumstances, in that case also he can change his opinion. The debtor is unable to pay the debt. So the resolution professional shall reject the application if. So who is rejecting? It is not the adjudicating authority is rejecting the application. It is the resolution professional is rejecting the application if in his opinion the debtor does not satisfy the conditions specified in the section 80, or the debts disclosed in the application by the debtor are not qualifying debt, or the debtor has deliberately made a false representation or omission in the application or in respect of the documents or information submitted. The resolution professional shall record the reasons for recommending the acceptance or rejection of the application in the report to the adjudicating authority under subsection 1 and shall give a copy of the report to the debtors. So resolution professional is recording the reasons whether the application can be accepted or not, and that he will submit to the adjudicating authority, and one copy has to be given to the debtor. Admission or rejection of application by adjudicating authority. So once the report is submitted by the RP, the adjudicating authority may, within 14 days from the date of submission of report by the RP, pass an order either admitting or rejecting the application. The order passed under subsection 1 accepting the application shall state the amount which has to be accepted as qualifying debt by the resolution professional, and such other amounts eligible for discharge under section 92 for the purpose of fresh start process. See, basically, if you see, there are all small amounts. There is no realization because is hardly having any assets. The income is very low. So whatever are the qualifying debt, mostly all qualifying debts will be discharged in this fresh start process. So here what happens is all those small loans will go away and the person can start with a fresh start. He can start his life with a fresh start. That is the objective of the fresh start process. The copy of the order passed by the adjudicating authority under subsection 1 along with the copy of application shall be provided to the creditors mentioned in the application within 2 days. So again, we have written copy to the creditor in 2 days of passing the order. Then on the date of admission. So what is the effect of admission? On the date of admission of the application, the moratorium period shall commence in respect of all debts. So once it is accepted, moratorium commences. During the moratorium, what will happen? No pending legal proceedings can happen, and no new proceedings can happen. During the moratorium period, the debtor shall not act as a director of the company, directly or indirectly, shall not dispose or alienate any of the assets, inform his business partner that he is undergoing a fresh start process, be required to inform prior to ending any financial or commercial transaction of such value as may be notified, either individually or jointly, that he is undergoing the fresh start process. Disclose the name under which he enters into business transactions if it is different from the name of application admitted under section 84. Suppose he has started some different firm, then he is supposed to say that he is doing the business in a different name. Not to travel outside India, as to avoid foreign travel. The moratorium ceases to have effect at the end of the period of 180 days, beginning from the date of admission. So we had seen initial moratorium or interim moratorium from the date of filing the application and from the date of acceptance of application. In between the process, before the acceptance of application, the RP gives his report whether to accept or reject. Based on the report, the adjudicating authority takes the call. Once the admission application happens, the moratorium begins and it ceases at the end of 180 days beginning from the date of admission, unless the order for admission is revoked. Otherwise, suppose in between the IRP feels that situations have changed and he calls for revocation of the order. So unless until there is a revocation of order, it will continue for 180 days. Objections by the creditors and their examinations. As you have said, always a creditor would not want his debts to be included in the qualifying debt. He wants his debts to be there in the excluded assets. So if he has certain objections for the inclusion of his debt in the qualifying debt, he would raise his objections under section 86 of this code. Any creditor mentioned in the order of the adjudicating authority under section 84 to whom a qualifying debt is owed may, within a period of 10 days from the date of receipt of order under section 84, object only on the following grounds. So on the 2 grounds, he can object. What are those 2 grounds? Inclusion of his debt in the qualifying debt. Not, so he will say not to include, this cannot be included. Or incorrectness of the details of the qualifying debt specified in the order. The details are incorrect. So not whether to include the debt or not, and the details of the debt. The creditor may file the objection by way of an application to the RP. So this application he will make it to the RP. The application under subsection 2 shall be supported by such information and documents as may be prescribed. The RP shall consider every objection made under this section. So this application is given to the RP, and the RP will consider each and every objection. The RP shall examine the objections and either accept or reject the objections within 10 days of the date of application. So RP is supposed to examine the objections. He is supposed to accept them or reject them within what is the time limit? Within 10 days. The RP may examine on any matter that appears to him to be relevant to the making the final list of qualifying debt. So he will take that matter and prepare his final list of qualifying debt. On the basis of the examination, the RP shall prepare the amended list of qualifying debt. So if he amends them, he will prepare an amended list of qualifying debt for the purpose of discharge order, make an application for adjudicating authority for directions under section 90, or take any other steps in relation to the debtor. Now suppose the debtor has not accepted the changes which was suggested by the creditor, and the creditor is unhappy with the decision of the RP. What can he do? So this is section 87, which says the debtor or the creditor who is agreed by the action taken by the RP under section 86 may, within 10 days of such decision, make an application to the adjudicating authority challenging such action on any of the following grounds, namely that the RP has not given an opportunity to the debtor or the creditor to make a representation, or that the RP colluded with the other party in arriving at the decision, or that the RP has not complied with the requirement of section 86. So requirement of 86 is that certain conditions were given here. RP is supposed to listen to them. All those conditions are there. Okay, he has to note down the objections, so which he has not done. In such cases, he can file an application with the adjudicating authority within 10 days. The adjudicating authority shall decide the application within 14 days of such application and make an order as it deems fit. Where the application has been allowed by the adjudicating authority, it shall forward its order to the board, and the board may take the action as may be required under chapter 4 of part 4, chapter 6 of part 4 against the RP. So that is the disciplinary proceedings might be initiated because he has not followed the code. So where the application, the adjudicating authority allows the application by the creditor or debtor, and where the RP has not followed it, in that case he will also forward a copy to the board. General duties of the debtor. What are the general duties of the debtor? He should provide timely information to the RP. He should provide the financial statements. Any omissions or others are there, he should provide those information. Those all duties are here. The debtor shall make available to the RP all information relating to his affairs, attend meetings, and comply with the request of the RP in relation to the fresh start process. He should provide all information relating to the affairs, attend meetings, inform the RP as soon as possible if any material error or omission in relation to the information or documents supplied to the RP, or any change in financial circumstances after the date of application where such change has impacted the fresh start process. So he should also inform any omissions or errors are there, or there is any change in the financial circumstances from the date of application until date. Earlier the position was bad, now the situation has changed. He has got some additional assets have come or any income has come, so that has to be informed to the RP. Replacement of RP. So where a debtor and the creditor doesn't want the RP, they want a new RP, what can they do? Where the debtor or creditor is of the opinion that the RP under section 82 is required to be replaced, he may apply to the adjudicating authority for the replacement of the RP. The adjudicating authority within 7 days of the receipt of application make a reference to the board for replacement of RP. The board shall within 10 days of the receipt of reference from the adjudicating authority recommend the name of insolvency resolution to the adjudicating authority against whom no disciplinary proceedings are pending. The AA shall appoint another RP for the purpose of fresh start process on the basis of recommendation of the board. Obviously, an opportunity of being heard will be given to the earlier RP, and if they find that actually some issues are there, only then they change. Otherwise, in the normal process, or sometimes there are certain reasons where the RP himself says that I want to change. Otherwise, generally they don't change in between. Okay, but still they have a there is a section which says the debtor and the creditor can apply for a change. Okay, the adjudicating authority may give directions to the RP replaced. So suppose the old RP is moving out and the new RP is coming. What is the duty of the old RP? First of all, he has to provide all the information to the new RP, and whenever the new RP calls him for information cooperation, he has to support the new RP so that he can move ahead. That is what it says. So this will be a normal section wherever you will see that a new RP or IRP is replaced by RP or RP is changed. This will be there. All the information has to be provided to the new RP, and he has to provide all cooperation to the new resolution professional as such manner as may be prescribed. Directions for compliance of restrictions, etc. The RP may apply to the adjudicating authority for any of the following directions, namely compliance of any restrictions referred to in subsection 3 of 85 in case the non-compliance of the debtors. We have seen various compliances which the debtor has to do in case he is not complying with them, or compliance of the duties of the debtor. There are certain duties which he has to provide all the information, which he is not doing that, he is not cooperating, he is not attending the meeting. In such cases, what the RP has to do? He has to apply to the adjudicating authority calling for directions. So directions will be given by the adjudicating authority. This is there in all the also there in the CRP process. The IRP or RP files various applications in the form of IA. They are called as interlocutory applications. See, the initial application is called as application for CRP. Subsequent applications, what are those applications we call it as? Any direction is required or any such cases, those directions are called as interlocutory applications. So he will be filing such applications, interlocutory applications here also, calling for directions of the adjudicating authority. The RP may apply to the adjudicating authority for directions in relation to any other matter under this chapter for which no specific provisions has been made. So any other matter also for which no specific provisions have been made, he can also ask for directions. It is always better to take directions rather than taking wherever the RP. In fact, various cases, it is always better to take a apply for the direction, because once a direction comes from the adjudicating authority, IBBI will not consider the RP as suppose if the code cannot be followed or various reasons. It is always better for the RP, rather than taking his own discretionary powers, better to apply with the adjudicating authority for directions. Because once there is a direction from the adjudicating authority, board will not come to the RPs. But yes, in all cases where where there is a claim which has to be processed, he cannot go with the, it is his jurisdiction and he has to approve or reject it. So it's not that all cases he can go, but yes, wherever he feels that this requires a direction, better to take a direction rather than taking his own decision. The RP, now revocation of order admitting application. So already an application has been passed, subsequently it has to be revoked. It will be revoked under section 91. The RP may submit an application to the adjudicating authority seeking revocation of his order under section 84 on the following grounds. What are those grounds? If due to any change in the financial circumstance of the debtor is ineligible for a fresh start process. Non-compliance with the debtor for the restrictions imposed. There were various restrictions, like he cannot be a director, he has to tell other persons that he is going through a fresh start process. Those conditions are there. He is not complying with the conditions. Or if the debtor has acted malified and has willfully failed to comply with the provisions of this chapter, the adjudicating authority shall, within 14 days of the receipt of application under subsection 1, may by order admit or reject the application. On passing the order admitting the application, the moratorium and the fresh start process shall cease to effect. So as I've said, the moratorium will be applicable for 180 days unless until it is revoked in between. The copy of the order passed by the adjudicating authority under this section shall be provided to the board for the purpose of recording and entry in the register under section 196. Now coming to the section discharge order. This is the section. See, why is the entire fresh start process is done? So that the assets are taken over and the liabilities are taken over and they are discharged. The RP shall prepare a final list of qualifying debts. So he will prepare the final list of qualifying debts and submit such list to the adjudicating authority at least 7 days before the moratorium period comes to an end. So what was those moratorium period? 180 days. So at least 7 days before. So this is the time which is given to the RP to submit the final list of qualifying debts. The adjudicating authority shall pass a discharge order at the end of the moratorium period for discharge of debt from the qualifying debts. So those qualifying debts will be discharged. So the debtor need not pay those debts. Adjudicating authority discharges interest, penalties, and other sums with respect to qualifying debt. Now here what has happened is, I have applied, RP has provided the details as on the date of filing the application. But suppose discharge order comes under 180 days. In between these 180 days, there are certain penalties which are imposed, there are certain interest which are imposed, and there are other sums which has been imposed. In that case, what should I do with these sums? So here it says in section 92, from the date of application till the discharge, all penalties, interest, and other sums with respect to the qualifying debt are also deemed to be discharged. This is what it says. Without prejudice to the provisions of section 2, the adjudicating authority shall discharge the debtor from the following liabilities, namely penalties in respect of qualifying debt from the date of application till the date of discharge order, interest including penalties, penal interest in respect of the qualifying debt from the date of application till the discharge order, any other sums owed under any contract in respect of qualifying debt from the date of application till the date of discharge. So if you see from the date of application till the date of discharge order, penalties respect to qualifying debt, interest and penal interest in respect of qualifying debt, any sums owned under a contract in respect of qualifying debt, for example, late payment charges or whatever charges, any other sums, they all are also discharged. Standard of conduct, the resolution professional shall perform such functions and duties in compliance with the code of conduct provided in section 208. Under 208, the code of conduct is provided. So the RP has to perform the code of conduct. So what now thing is, these are the acronyms which you have written. So are you able to identify that section along with the acronym? Just go through. So this is what I used to do. I used to read the code and write it about the section and then pull it in the index. And so what happens is this, if we read again and again, we are able to remember the story. If you see, the story is very simple. The code is very simple. If you see, I have mostly copied the code and made my presentation. I have not changed much of the words. It is similarly, my presentation is more or less reading the code itself. It was very comfortable. You have gone through the code similarly, but now what happens is the number of dates which are there. So in the index of sections, write all those acronyms so that if you read them again and again, you will remember the sections. I'll just give you 1 or 2 minutes just go through them. So this was my style of remembering. You can have your own methodology to remember the sections or numbers, dates. You can also have some simple flowchart of this sort where you can remember the entire process. So what it says, fresh start process, complying with the prerequisites. We have seen various conditions. Application for filing an application for the fresh start process. Okay, how can it happen? It can happen that debtor can file by himself or through the resolution professional. Once the filing is done, interim moratorium commences. Appointment of resolution professional happens. Application is examined by the resolution professional. Then decision is taken by the adjudicating authority, and then the moratorium starts. So at the time of initial filing, interim moratorium happens. Then after the interim moratorium, resolution professional examines the application and then provides his report. Based on this report, the final decision happens. Once the final decision happens, the final insolvency resolution process happens, the moratorium commences. There might be objections by the creditors. Okay, the creditors may ask for replacement of the RP, and then the final list of qualifying debts by resolution professional will be submitted to the adjudicating authority, and then the final discharge order happens. So you can form such type of flowcharts. You can have such flowcharts for easy remembrance. Now coming to the chapter 3, insolvency resolution process, section 94 to section 120. So now if you see fresh start process, section 80 to 93, it is basically for small lenders basically who are taken small loans. For them, the fresh start process is applicable. Now, for a normal person who is not coming under fresh start process, he has to come into insolvency resolution process, because fresh start process will come in only under those 7 conditions if they are satisfied, and the amounts are very meager. Otherwise, it will come under chapter 3 insolvency resolution process, and if the insolvency resolution process doesn't happen, it goes under the bankruptcy order. So bankruptcy order, the process is not automatic. We have to trigger the bankruptcy order by filing an application with the adjudicating authority separately. Yes.
Ritesh, sorry for interrupting you.
No problem. No problem.
Can we take a break?
Yes, not an issue. For how
Because
many
for the
minutes?
music- Yeah, at least 10 minutes.
Yes. Okay.
10 minutes, please.
Yes.
Let's will rejoin again after 10 minutes.
So should I re-log in, or it will be on? The login will be
No.
same.
Just stop video and
Okay,
mute
fair
it.
enough. Yes.
Have some cup of tea and come back, please.
Thank
Again,
you.
once.
Okay, sure. Yes.
If it is a branch, we could able to arrange this. We can save only. Thank you.
Sure. Yes. Thank you. Shall we start? Done. So now coming to the part 3, insolvency resolution process, section 94 to 120. So now if we see in chapter 1, we have discussed about 3 sections, which was qualifying debt, excluded debt, and excluded assets. So those sections from 78 to 79 is applicable for all chapters. So is that applicable for fresh start process also? Yes. Are they applicable for part chapter 3? Yes. Chapter 4, that's all. So the preliminary sections will be applicable for all chapters, but certain specific chapter sections, definitions will be applicable only for that chapter. Now, for example, as you have seen under fresh start, there were 7 conditions. So one condition was it should not have any dwelling unit, whereas the preliminary section says to under a excluded asset, he can have one dwelling unit up to 20 lakhs and 10 lakhs. So that means these additional sections for fresh start process, there were additional sections. So now when we start again with the insolvency resolution process, we should also know what are those qualifying assets, what are those excluded, qualifying debt, what is the excluded debt, and what are those excluded assets. So what is a qualifying debt? Qualifying debts are all debts apart from other than excluded debt, then secured debt, and any debt which has happened just 3 months before fresh start process. Okay. Now, what are excluded debt? Excluded debts. We'll just come back here. Excluded debts are any liability in way of fine, damages, maintenance, students' loans, or anything which has been specified. And then coming to excluded assets, unencumbered tools, unencumbered furnitures, unencumbered personal ornaments, unencumbered life insurance policies, and unencumbered single dwelling unit. So now, as we have seen, fresh start process has not yet been notified. Now, in that case, is chapter 3 notified? Chapter 3 is notified only to the extent of personal guarantors of a corporate debtor. To that extent, it is notified. So chapter 3, chapter 4, chapter 5 have been notified only to that extent of personal guarantors. So suppose I have taken a loan from a bank and I have not paid the amount to the bank. Okay, so I am an individual or a partnership firm. Can I be taken into IBC? No, because as such, as I have taken the amount in person and not as a guarantor to a company, so I cannot be taken into IBC. The bank has other remedies which might be under SARFACI or any other remedy, but there is no remedy under the IBC as of date because this section has not been notified. So insolvency resolution process coming to chapter 3. So insolvency resolution process is in lines with what we have seen under corporate insolvency resolution process. So as you have seen, the corporate insolvency resolution process is a period of 180 days, which can be extended for another 90 days, wherein what happens? The IRP comes over, he calls for the claims. Okay, he gives a public announcement, calls for date, calls for claims, then constitutes a committee of creditors. Then they call for expression of interest for a resolution plan, issuing the information memorandum, and he receives the various resolution plans. Based on the resolution plans which are put for the committee of creditors, if the committee of creditors approves a resolution plan, will be taken by the adjudicating authority for the approval. If the resolution plan is approved, in that case, it will be binding on all the creditors and the debtors. If it does not get approved, then the liquidation is initiated. So it is basically in lines with the lines. So instead of corporate insolvency resolution process, corporate now has been removed and it is called as insolvency resolution process, section 94 to 120. Now, so what we have to see is section 94 to 120. Apart from that, what should I read? We have to read the rules and the regulations. Rules are only when it comes to application for adjudicating authority. We have rules, and regulations are for each chapter wise. We have various regulations. So for this part, for this chapter 3, we have one rule and one regulation. Application to adjudicating authority. So insolvency resolution process for personal guarantors to corporate data rules, and IBBI insolvency resolution process for personal guarantors to corporate data regulations 2019. This is the syllabus. This is the provisions applicable. Where do I get all the chapters and regulations? Is it available somewhere? Yes, they are available at the IBBI website. I'll just show you the IBBI website also. Just a minute. Share. So this is the website of the regulator, ibbi.gov.in. First of all, I'll show the examination section, limited insolvency examinations. So here what happens is the examination has to be notified at least 3 months before. So here for us, the applicable is 1st of January 2021. This is here. And then here we have the syllabus. This is the syllabus which was notified on 30th of September. So 3 full months, October, November, December, that is. So it was notified on 30th of September, and it is with effect from 1st of January. And these are the topics, and these are the weights of marks. Okay. And then it is applicable whenever any law, act, or parliament or rule is referred in the syllabus, the same shall be taken into force as on 31st of December 2020. So till 31st of December 2020, whatever amendments or notifications have happened, this will be taken into. So that means anything after 31st of December 2020 will be ignored for the exam. Now, where do we get the case laws? So the list of case laws is there under part 7. If you see, if you click there, the list of case laws will come there. Then if you see the syllabus, what is the weight which is given for the insolvency and bankruptcy? If you see, the IBC code is 10 marks, the regulation is 15. So 15 plus 10 is 25. 25, and these are the Indian Contract Act, Secure Act, General Awareness, case laws, 25 plus 10, 35. Case study for corporate insolvency resolution process, so 20 marks. So 35 plus 20, 55. 55. Then coming for case study for individual insolvency resolution process, 55 plus 8, which comes to 63. 63 case studies on companies, partnerships, firms, and limited insolvency partnership. There will be one narrative case study. So 63 plus, you can say, and again, professional ethics. So 63 plus, basically, you can say 12. So around 75 marks. 75 marks are from the code. Then apart from then, 25 marks are from various other topics like Companies Act. We have 4 marks. Indian Contract Act, Negotiable Instruments Act, Transfer of Property. There are all so many acts which will have for 11 marks. Finance and accounts, including financial analysis, liquidity, GST, 5 marks. General awareness, 5 marks. So that means the major focus should be on the code. You cannot leave even a single line of the code if you want to pass. All topics, see, it is like a CS syllabus. Nothing will come outside the syllabus. Everything will be there within the syllabus. So if you read everything, there is hardly any possibility of. So, but only thing is, if we don't, since there is a negative marking, wherever we don't know the answers, or you just have to leave the answers rather than giving incorrect answers. Now coming to the legal framework. Where is the code? Suppose if I want to have the latest code, it is there here under the Act, Insolvency of amended up to. So here up to. So if you see various dates, the code is given here. The rules are here. What type of rules are here? The rules are for basically adjudicating to application to adjudicating authority rules are here. Then if you recently a pre-packed insolvency process, this is not applicable because this has come in April. for examination purposes as of date. Then these are both various rules which are given here. There are again rules with respect to the medical facilities, salaries, allowances. So majorly rules are for application to adjudicating authority. Rules are here. Then coming to regulations. Regulations are for various chapters. As I've said, various regulations are applicable. For example, for this topic of presently what we are doing under chapter 3, insolvency resolution process, we have the regulations under insolvency resolution process for personal guarantors. So control F was. So here we are having the personal guarantors, IBBI bankruptcy process for personal guarantors, IBBI insolvency process. The first stage will be insolvency process and the second stage will be bankruptcy process. So these are the two regulations with respect to personal guarantors. Similarly, we'll have two rules for personal guarantors. So we have the application to adjudicating authority for insolvency resolution process for personal guarantors rules, and then the application to adjudicating authority for bankruptcy process for personal guarantors rules. They are here. Now, apart from that, we have various orders of the Supreme Court, High Court, NCLT, NCLAT are here, and this can be seen here. And on the home page, we have the IP login. Subsequently, there is various compliances has to be done by an IP. So he has to log in there, and then the CPE requirement, IP login, all those forms uploading has to be done there. Then for publics, they can see what are the companies which have gone into CRP process. So public announcement, what are the companies which have made a public announcement can be seen here. And the list of companies and the the public announcement in Form A can be viewed here. Public insolvent, public announcement for CRP process. There are again three subcategories: public announcement for corporate insolvency resolution process, public announcement for voluntary liquidation process, public announcement for liquidation process. So we'll give the details which public announcement has been made under Form A, and then subsequent invitation for resolution plan under Form G can be seen here. As you all know, the public announcement will be there, one in the newspaper local language and one regional language of the most circulated newspaper. Then secondly, it has to be there on the website of the company and the corporate data, and the third will be on the website of the IBBI. So here, this is the third category where so as soon as the public announcement is given, immediately it is uploaded on the IBBI website through the IP login. So once it is uploaded, it flashes here. So this is the IBBI website. It is for various details. Now we'll start with again with our PPT. So here the insolvency resolution process, we have to go through the code and we have to go through the application for adjudicating authority rules and the application for regulations for personal guarantors regulations has to be covered here. Now, how the application for initiation happens? It can happen, the application can be filed by the debtor, the application can be filed by the creditor. This is something in line with we have seen under section 7, 9, and 10 of the IBC code, wherein the CRP is initiated by a financial creditor under section 7, by a operational creditor under section 9, and by the company itself under section 10. So the debtor himself, if he is initiating, he will be filing under section 94, and the creditor, if he is initiating, he will file under section 95. As we have seen, there is no distinction in the individuals and partnerships whether for financial creditor or operational creditor. In fact, the secured creditor is basically not included in the claims itself, qualifying amount of itself. So here there are two sections, 94 and 95, where the initiation can happen. So along with these two sections, what should we go through? We have to go through the rules. Application for adjudicating authority for insolvency resolution process for personal guarantors to corporate debtor rules 2019 has to be read here. So 94, 95 along with application for insolvency resolution process rules has to be read there. So under 94, the application can be filed by the debtor. So under Rule 6, the form A is the form which we have to upload. The fees is 2000. The who has committed a default of debt other than excluded debt. So there is a default of debt and the debt may not be excluded debt. So the application can be filed either personally or through the resolution professional. In the case of the partnership, by majority of the concerned partners. So now here, if we see again, there is one more similarity between fresh start process and the insolvency resolution process. The debtor or the creditor can file. They can file himself or through the resolution professional. That these two options are there. Then it can be filed by the creditor under Rule 7 under Form C. Fees is 2000, either individually or jointly through other creditors, directly or through a resolution professional. Only if the debtor fails to pay within 7 days of the service of demand notice. Now there is an additional condition here. The creditor, if he is initiating the insolvency resolution process, in that case, he should give 14 days of service of demand notice. So this is in line with section 8 of the IBC code, wherein before the operational creditor files an application under section 9, under section 8, he has to issue a demand notice for 10 days. So here the demand notice is for 14 days. So the demand notice is in form B. There it was form 3 and form 4. Okay. The demand notice was in form 3 and form 4. The petition. Yes.
Can you change the PPT mode, slideshow?
Yes, sure. Okay. So here, there it was the demand notice was issued in form 3 and form 4. Here the demand notice will be issued in form B. So what are these three forms totally? Application, if it is filed by the debtor, it is form A. Application, if it is filed, the demand notice is in form B, and if the application is filed by the creditor, it is in form C. So these are the three forms which you are seeing. Then debtor's ineligibility to file an application. In what cases? See, debtor can file an application in normal circumstances. In what cases he cannot file an application? So this is a debtor shall not be entitled to make an application under an undischarged bankruptcy. He is already undischarged bankrupt. He is already going a fresh start process. He is undergoing an insolvency resolution process or undergoing a bankruptcy process. So already he is going the process and again he is filing an application. Not possible. A debtor shall not be eligible to apply if the application under this chapter has been admitted in respect of the debtor during the period of 12 months preceding the date of submission of application under this chapter. So already within preceding 12 months, the application has been admitted. Again, he cannot apply. The application shall be in such form and manner accompanied by such fees as may be prescribed. So it's basically referring to the rules. Now, application for initiation by creditor. Coming to section 95, continue. Then application under subsection 1 shall be accompanied with such details and documents relating to the debt owed by the debtor to the creditor or creditors, submitting an application for insolvency resolution process as on the date of application, the failure by the debtor to pay the debt within a period of 14 days of service of notice of demand, and relevant evidence of such default for non-payment of debt. So that means before the creditor files an application under section 95, he has to issue a demand notice giving the debtor 14 clear days. And only when after the 14 days, if the debtor is not paying the amount, only then he can file an application for initiation of insolvency resolution process under section 95. Now coming to withdrawal of application. Once an application is filed, can it be withdrawn? Rule 12 says, Rule 12 of the application for adjudicating authority for insolvency resolution process for personal guarantor says, the adjudicating authority may permit the withdrawal of application under Rule 6 or Rule 7, as the case may be, before the admission of the request made by the applicant, after its admission, or request made by the applicant if 90% of the creditors agree to withdraw. An application to withdraw shall be in Form D. So we are seeing Form A, B, C, and D. Now here if we see, application for withdrawal has to be given by whom? The request for withdrawal has to be given by whom? It has to be come from the applicant. It has to come from the applicant. So it says, before the admission on the request made by the applicant, after its admission on the request made by the applicant. So that means, so though it is many of the times it so happens that, suppose this is also there in the CRP also. If subsequent to the initiation of CRP, if the withdrawal has to happen, it has to be filed by the applicant himself only in form number FA. And if it is before the COC meeting, if it is before the constitution of the COC meeting, straight away the IRP or the RP can take the application with the adjudicating authority. If it is after constitution of the COC, he has to take 90% approval of the COC meeting, and then he has to file the application with the adjudicating authority. So that means the person who has filed the application, okay, or the person who has initiated the CRP, or the creditor who has initiated the CRP, only he can withdraw the application. Okay, it is not that 90% of the COC are accepting, but this creditor who has filed the application is not accepting. Can the application for withdrawal can happen? No, because the request should be made by the applicant. Subsequently, after the submission, the request should be made by the applicant if 90% of the creditors agree. So first, there are two conditions. The request should be made by the applicant and 90% of the creditors has to accept. Then the application can withdraw. So it is always better to be an applicant rather to be a normal claimant, because if the withdrawals, I'll tell you my situation. In one of the case wherein I have been an IRP, they were along with me, they were totally around 7 to 8 cases which were pending against the company. So as soon as I became the IRP, on the next hearing, all the 8 to 9 cases came for hearing. Okay. Now, what should I do as a, because they are again for initiation of CRP. Now, what should they do? Now, here in this case, what happened is, since the CRP is already initiated, will all those cases will be called off because CRP is already initiated by one of the persons. It is already initiated. So what the bench did is, what they did is, all the other cases, they have postponed for 1 month, or they gave the hearing for 1 month. And they said, if in this time period, if the withdrawal happens, all the subsequent cases will continue. And in this process, if the withdrawal doesn't happen, in that case, next hearing, because after the COC is constituted, if still the withdrawal doesn't happen, in that case, in the next hearing, all the other cases will be withdrawn because CRP is already initiated. Subsequently, the case came for withdrawal, the withdrawal happened, and next continued cases happened. Subsequently, what happened? Again, the company came into CRP, again it went to withdrawal. And it is now the stage that it might happen that the third time the company might go for CRP. So it is many of the times happens that the creditors file for CRP, the applicant satisfies him, he withdraws. Again, since the other cases are pending, again the company goes into withdrawal, and again it is withdrawn, and these processes are happening. So it is always better. Suppose you might have a situation wherein it might be a case where you might think that someone else is already going into CRP. Should I also proceed? It is always better to be an applicant and be an applicant who is taking the company into CRP, because In case of withdrawal, in case the company wants to withdraw, the first person whom they have to satisfy is the applicant. Okay. So this is where it is saying before the admission on the request made by the applicant, after the admission again on the request made by the applicant, with 90% creditors agreeing for withdrawal in Form D. Now coming for the insolvency resolution process. So insolvency resolution code 94 to 120 will go along with the regulations we'll go through. This is the flow chart. How does it say? Application for initiation of insolvency resolution process. Okay. First stage is RP is appointed. RP gives a report and then it goes, RP goes. So that means here also the process is adjudicating authority is delegating some of the job to the RP. RP will form an opinion, will submit a report. RP is given 10 days of time to constitute a report, and then the adjudicating authority will take over the case. So the first stage is appointment of RP. Okay. Then once the RP is appointed, RP will submit the report, and then the final order of the adjudicating authority will come. Now, suppose admission happens. In that case, what will happen? If suppose admission doesn't happen, the creditors are entitled to file for bankruptcy. Okay. That is the third part. If admission happens, then the adjudicating authority will give a public notice. So like public announcement, what we have seen in the Form A, they have shown you those forms. Similarly, here the public notice will be given by the adjudicating authority in how many days? 7 days. There under CRB, the number of days is 3. The IRP is given only 3 days of time for public announcement. Here the time given is 7 days, and the public announcement will not be done by the RP, it will be done by the adjudicating authority. What is this public announcement? It is a public announcement calling for claims. The creditors are requested to submit the claims in the claim form as may be notified in the respective claim form. So now the creditors will submit the claims. They are given 21 days of time. What will happen? The RP will put in a list of creditors. Okay. The RP will put in a list of creditors in 30 days. And then this, based on this, the creditors claim the debtor is going to come up with a repayment plan. It is basically, it is not a resolution plan, which we have seen under CRP. It is a repayment plan, because the resolution plan comes from the third person who is going to take over the company as a going concern. It is not a resolution plan, it is a repayment plan. Basically, like what we have seen under restructuring, wherein some amount is reduced, banks, they go for one-time settlement or such processes. So the debtor will propose his repayment plan. Now, what will happen in this repayment plan? The RP will submit the repayment plan to the adjudicating authority along with his own report. And then the adjudicating authority, if it is satisfied, straight away it may approve the repayment plan, or it may ask for calling for the meeting of creditors. Okay. So here it is meeting of creditors. In this, creditors are all creditors, including operational creditors, is also included. Yes. All financial creditors, operational creditors. Financial creditors means obviously unsecured creditors will be included. Secured creditors obviously will not form part of qualifying debt. So they are anyway out. So all unsecured creditors, financial creditors, including operational creditors, will be here. So there will be a meeting of creditors. Now what will happen? What will the meeting of creditors they will do? They will take the repayment plan. Okay. They will say, okay, this we are accepting, but this term we have little bit of unacceptance. So again, it will go to the debtor. He will accept each and every modification, because they will not accept the repayment plan which is given by the debtor. They would say, no, we are not going to waive off the interest. Okay, we will do one thing. We will make the interest of so and so. So they are making a modification. If they are making a modification, again, the modification has to be accepted by the debtor. So all the modifications has to be accepted by the debtor. If he accepts, again, the card becomes a part of the repayment plan. Then once the final repayment plan is coming, the report on the meeting of the RP. So he will take that report and again he will submit to the NCLT. Okay. Then NCLT will pass an order, meeting of data. So it is not necessary that there has to be a meeting of data. They can straight away know and order for adjudicating authority. Adjudicating authority, if it approves the repayment plan, it will become binding on all the creditors and debtors. Then if it does not approve, both the debtor and creditor are entitled to file for bankruptcy order. That is the third stage, liquidation. What we said, the liquidation, it is called here bankruptcy process. So basically here the crux is, if you see, there will be a repayment plan which will be proposed by the debtor, and that repayment plan will be put in to the adjudicating authority and the meeting of creditors. And if they accept the repayment plan, everyone, it will be binding on the debtors and creditors. This is the overall flow chart. Now again, moratorium, as we have seen, there are two types of moratorium. As soon as they file the application, there is an interim moratorium. As soon as once the application is accepted, there will be a final moratorium. Again, it is from admission till 180 days. So for this entire process, the time given is 180 days. What type of all pending and new will be stayed. Here also all pending and new proceedings will be stayed. And in this moratorium, in this final moratorium, the debtor shall not transfer, alienate, encumbrate any of his assets or legal rights. He cannot transfer his assets. This is what it says. Then public notice and claims from creditors. Yes, this is section 102. The adjudicating authority shall issue a public notice within 7 days. So here, the adjudicating authority shall issue a public notice within 7 days of passing the order in Form B for all creditors within 21 days of such issue. So here, the creditors had to submit their claims in Form B. There are no various forms. Whereas in CRP, for financial creditor, there is a different form. For operational creditor, there is a different form. For other than financial and operational creditor, there is a different forms. For housing creditors, there are different forms. But there are no different forms here. There is a single form B here. The notice shall include the details of order admitting the application, particulars of the resolution professional with whom the claims has to be registered, and the last date for submission of claims. The notice shall be published in one English, one vernacular language, and affixed at the premises of the adjudicating authority and the website of the adjudicating authority. So here the notice will be on the website and English newspaper and vernacular newspaper where the debtor resides, affixed at the premises of the adjudicating authority and the website of the adjudicating authority. Suppose if it is NCLT, it is going through that, it will be affixed on the premises of NCLT or the website of NCLT. Registering of claims by debtors. The debtors shall register the claims with the resolution professional informally by sending the details of the claims by way of electronic communication or courier, speed post, or registered letter. Whereas in the case of CRP, if it is a financial creditor, he has to submit the claim only by electronic mode. Whereas for the operational creditors, have an option to submit both by electronic mode as well as a physical mode. So here, a Form B can be submitted both by electronic mode, courier, speed post, or registered letter. In addition to the claims, the creditor shall provide to the RP personal information and such particulars as may be prescribed. In the form, there will be some personal details which will also be required. What will the RP do with these claims? He will prepare the list of creditors on the basis of the information disclosed in the application filed by the debtor under 94 or 95 as the case may be. Claims received by the RP under section 102. So if you see here, the list of creditors is prepared not just from the claims received under section 102, it is also prepared from the information disclosed in the application filed by the debtor under 94 or 95. For example, as a creditor, I have filed an application against the debtor for initiation of insolvency resolution process. The RP can take the details and include me in the list of creditors based on the information or based on the application which I have filed. Whereas in the case of CRP process, suppose a section 7 initiation has happened, subsequently, can the IRP include his name in the COC meeting without taking a claim form? No, he has to again request the creditor, though he is a section 7 applicant, okay, or operational creditor anyway will not form part of the COC member. So though he is a section 7 applicant, automatically his name will not form part of the COC. He has to again submit a claim form. Whereas here, the RP shall prepare the list of creditors based on the information which is submitted under 94 or 95 or the claims received by the RP under section 102. The resolution professional shall prepare the list within 30 days from the date of notice. So he will 30 days are given him for him to prepare the list of creditors. Now this is the repayment plan. Who will prepare the repayment plan? Debtor is going to prepare a repayment plan. The debtor shall prepare in consultation with RP a repayment plan containing a proposal to the creditors for restructuring his debt of affairs. So he is giving a proposal to the creditor. You restructure my assets in so and so. Either you increase the period instead of paying in 3 years, I will give me a time so that I will pay in 6 to 7 years. Or he may say that kindly reduce my interest rate. Okay. So because see, probably we have seen the CDRs, SDR schemes in the banks wherein they restructure the loans. So the repayment plan is a sort of restructuring which the debtor is proposing to the creditors. So this is called as the repayment plan. The repayment plan may authorize or require the RP to carry on the business, debtor's business or trade on his behalf or in his name. So this may authorize. So in this process, in this time period, the business is going on. My business will be carried on by the RP. He will realize the assets of the debtor or administer or dispose of the funds of the debtor. So who will see here the repayment plan? He is authorizing the RP to do such things. So what he can do, he can carry on the business, he can realize the assets of the debtor, he can administer or dispose of any funds of the debtor. Whereas in this case of CARP, the resolution applicant who submits the resolution plan says how the plan will be executed. He will give the steps in which the plan has to be executed. Whereas here, the repayment plan and the process of execution, the powers are given to the RP. The repayment plan shall include the following, namely, justification for preparation of such plan and reasons on the basis of which the creditor may appear on the plan. What is the justification of the repayment plan? He will say, well, on these reasons it is justified. He doesn't have any assets or he cannot pay and his income is less. This is the justification and the reasons for which the creditors may agree and why they can agree, why they have to agree. See, they can say, though the interest is reduced, the period is different, but they are getting the lesser interest. So he has to justify from both the sides, preparation of repayment plan and reasons why the creditor has to accept. The provision for payment of fees to the RP, how much fees is coming to that, such other matters as may be specified. Summoning of the meeting of creditors. The resolution professional shall issue a notice calling for the meeting of creditors. So in the case of CRP, it is called as COC, Committee of Creditors. Here it is called as MOC, meeting of creditors. Okay, MOC will be like memorandum changes we go through. Will not get it. Call it as meeting of creditors. We'll see once. See here we don't. The acronyms are not much in use because these processes have not yet started. Whereas there the CRP acronyms are much in use, like IRP, RP, COC. Okay, resolution plan. Those all acronyms are now well in use. So probably we have to see what acronym they'll give it to it, whether it will be called as meeting of creditors or MOC. Time has to say. At least 14 days before the date fixed for such a meeting. So the resolution professional shall issue the notice for meeting of creditors at least 14 days before the date of such meeting. Okay. The RP shall send a notice of the meeting to the creditors prepared under section 104. The notice shall state the address of the adjudicating authority, to which the repayment plan and the report of the RP on the repayment plan has been submitted and shall accompany by a copy of the repayment plan, a copy of the statement of affairs of the debtor, a copy of said reports of the RP, and the form for proxy voting. So suppose some creditor is not able to attend on his own, he can call someone to attend and he can give a proxy voting also. The proxy voting, including electronic voting, shall take in place in such manner as may be specified. So what is the objective of the meeting of creditors? The objective of the meeting of creditors is take the repayment plan, to see the statement of affairs and to see the report of the RP, because he has already given a report to the adjudicating authority. They will take that report and now they will form an opinion or they will approve the repayment plan. The meeting of the creditors shall be conducted in accordance with the provisions of section 109, 110, 111. The meeting of creditors, the creditors may decide to approve, modify, or reject the repayment plan. The RP shall ensure that if modifications are suggested by the creditors, consent of the debtor shall be obtained for each modification, because if the creditors are asking for modifications, debtor should accept those modifications. So each modifications, the consent of the debtor is accepted. That is the responsibility of the RP. The RP may, for sufficient cause, adjourn the meeting of the creditors for a period not more than 7 days at a time. So if he has to adjourn, he can adjourn for 7 days at a time. Now, there are certain regulations under regulations 11. Now, which regulations? Insolvency and Bankruptcy Board, Insolvency Resolution Process for Personal Guarantors regulations. Regulation 11 talks about meeting of the creditors. The resolution professional shall convene the first meeting of the creditors and shall convene the meeting by giving such notice to other participants as decided to the creditors, which shall not be less than 48 hours. So the maximum time we have seen here, it shall not be less than 48 hours. The resolution professional shall convene the meeting of creditors on the request of the creditors having 33% of the voting share of creditors. Now, what happens is the creditors are coming forward and asking the RP to convene the meeting of creditors. How many creditors? 33% of the creditors are coming forward and asking the RP to convene a meeting. It is the responsibility of the RP to convene a meeting. The notice under this regulation shall be served on every participant at the address provided to the RP in accordance with regulation 12. Unless otherwise provided to the court, any decision of the creditors shall require approval of more than 50% of the voting share. So the number of the creditors who voted. So because once the creditors come for voting, they have three options: to approve, reject, or abstain. Suppose the number of people who abstain from voting is 60%. So balance people who are voting is only 40%. Can I approve? No. What it's saying, any decision of the creditor shall require the approval of more than 50% of the voting share. So of the total voting share, more than 50% of the people have to approve. Then quorum. The meeting of the creditor shall be quorate if the creditors representing at least 33% of the voting share are present in person or by proxy or through video conferencing. So out of the total creditors, 33% of the amount of creditor of the total value of the creditors will be the quorum. Okay. Provided that the creditors in a meeting may modify the percentage of voting share required for quorum in respect of future meeting of creditors. Subsequently, the creditors can modify. Where the meeting of the creditors could not be held for want of quorum, unless the creditors have previously decided otherwise, the meeting shall automatically stand adjourned to the same time and place on the next day, and on that day, no quorum shall be required. Similarly, we have seen the similar lines in CRP regulations also. The meeting shall stand, next day it shall stand adjourned to the next day. Voting rights in the meeting of creditors. The creditors shall be entitled to vote at every meeting of the creditors in respect of the repayment plan in accordance with the voting share assigned to them. So now, for example, the total amount due is 20 lakhs. So one creditor, his due amount is 2 crores. So his voting share is 10%. So that way the voting share will be decided based on the total, based on the voting share assigned to him. The resolution professional shall determine voting share to be assigned to each creditor in the manner specified by the court. Creditor shall not be entitled to vote in respect of the debt for an unliquidated amount. So if what is liquidated amount or unliquidated amount? Unliquidated amount is that amount which cannot be quantified. Okay. So it should be only for those amounts which are quantifiable. So amounts which cannot be quantifiable, like contingent liabilities or those things, will not be taken into consideration. The creditor shall not be entitled to vote in the meeting of the creditor if he is not a creditor mentioned in the list of creditors under Section 104 or he is an associate of the debtor. So if he is not mentioned in the list of creditors under 104, he will not be entitled to vote, or if he is an associate of the debtor. So associate of the debtor is also again excluded from the meeting. Now coming to Regulation 5, voting by creditors. The resolution professional shall take the vote of the creditors present in the meeting on any item listed for voting after discussion on the same. At the conclusion of the meeting, the resolution professional shall prepare the minutes of the meeting, including the names of the creditors who voted for, against, or abstained from voting on the items put to vote on the meeting. So on the agenda items, he will see who have voted, not voted, or abstained. Now what? The resolution professional shall circulate the minutes of the meeting by electronic vote to all the participants of the meeting within 48 hours of the conclusion of the meeting. So the minutes has to be circulated within 48 hours. Seek a vote on the items listed for voting in the meeting from the creditors who are not present in the meeting or did not vote at the meeting by electronic means, where the voting shall be kept open for at least 24 hours from the circulation of the minutes as in clause. So within 48 hours, he has to send the minutes, and then those who have not voted, again, he will give the time for 24 hours to vote on electronic means. Okay, I think this in CARP it is again 24 and 24. 24 hours, within 24 hours he has to send the minutes of the meeting, and within next 24 hours he can take the uh, voting of the people who are not voted. Then at the end of the voting period, the resolution professional shall record the decision arrived. So initially what will happen is, initially he will have the minutes. People, so based on that he will have a percentages. Certain people are abstained. Again what will happen? He will get some more voting. Based on that, again he will draw the agenda items and the amount of voting. So that will become the final voting. At the end of the voting period, the resolution professional shall record the decision arrived at on the items along with the names of creditors who have voted for, against, abstained for voting on the items. After considering the voting at the meeting and through electronic means, the RP shall circulate a copy of the record made under the sub-regulation 4 to all the participants within 24 hours of the conclusion of the voting. So after the conclusion of the second voting, within 24 hours, he has to send the copy of the records. What if someone wants to have a proxy? How can he have it? Suppose I am not able to attend and I want someone else to attend on my behalf. So he can appoint a proxy. A creditor who is entitled to vote at the meeting of creditors shall be entitled to appoint an individual who shall not be an associate of the guarantor. So again, the proxy also should not be an associate of the guarantor as a proxy to attend and vote on the behalf. The creditor shall deliver Form C duly completed to the resolution professional at least 24 hours prior to the meeting of creditors. So at least 24 hours before the Form C should reach the resolution professional. The proxy may vote by electronic means or means on behalf of the creditor. They vote by electronic means on behalf of the creditors. Now coming to secured creditors. As we have seen, secured creditors, will they form part of a qualifying debt? No. So that means secured creditor, if he still wants to be a secured creditor, he cannot participate in the meetings. But suppose he says, I will relinquish my right. Okay, I will relinquish my secured rights relinquished, entitled to vote at the meeting of creditors. So he says, I don't want to be a secured creditor. I relinquish my right. So my entire amount becomes unsecured. In that case, he can participate at the meeting. But if he submits, and he does not do that, submit an application, shall be entitled to vote only in respect of unsecured amount. So suppose if he still continues to be a secured creditor, in that case, he will be part of he can participate in the minutes only to the extent of the unsecured debt. Now, approval of repayment plan by creditors. The repayment plan or any modification to the repayment plan shall be approved by a majority of more than 3/4 in value of the creditors present in person or by proxy. So 3/4 in the sense 75%. The majority of 3/4 in value, 75% of the creditors, if they approve, present in person or by proxy. So the total to the extent of the creditors who were present, if 3/4 of them in value approve it, the repayment plan will be approved. Voting on the resolution in a meeting of creditors. Report of the meeting of creditors on repayment plan. So now again the RP is going to prepare a report. Okay, the RP shall prepare a report of the meeting of creditors on the repayment plan. The report shall contain what? Whether the repayment plan was approved or rejected, and if approved, the list of modifications, the resolutions which were proposed at the meeting and the decisions on such resolution, list of creditors who were present and are represented at the meeting, and the voting records of each creditors of all the meeting of creditors, and such other information as the resolution professional thinks appropriate to be known to the adjudicating authority. The resolution professional shall provide copy of the report of the meeting of creditors prepared under section 99 to the debtor, creditors, and the adjudicating authority. Now the adjudicating authority, what will it do? After it has received the copy of the report from the resolution professional, it shall by order approve or reject the repayment plan. So it can approve it or reject the repayment plan on the basis of the report of the meeting of creditors submitted by the resolution professional under section 112. Provided that where a meeting of the creditor is not summoned, the adjudicating authority shall pass an order on the basis of the report prepared by the RP is resolution professional, it should be resolution professional or the professional should go by the RP under section 106. So basically what it says is, as we have seen, in case 33% of the creditors ask the RP to convene a meeting, then it becomes mandatory for the RP to convene the committee of meeting of the creditors. If suppose that condition is not there and no one asks the RP to convene the meeting of creditors, in that case, he need not convene the meeting of creditors and straight away he can submit his report to the adjudicating authority and the adjudicating authority shall pass. So that means convening a meeting of creditors is not mandatory. Convening a meeting of creditors is not mandatory. It is unlike CRP where convening a meeting of COC is mandatory. Okay. The adjudicating authority approving the repayment plan may also provide for directions for implementation of repayment plan. So they may also provide for directions of implementation. Where the adjudicating authority is of opinion that the repayment plan requires modifications, it may direct the resolution applicant to reconvene a meeting of the creditors for reconsideration of the repayment plan. Already the meeting of creditors asked for modifications and the RP ensured that those modifications are accepted by the debtor. Now the adjudicating authority may also require some modification. So again, it will go to the debtor for modification he has to accept. And then again, a meeting of creditors has to be convened and considered. So they go back to scale 1. Effect of order of adjudicating authority for repayment plan. Where the adjudicating authority has approved the repayment plan under section 114, the repayment plan shall take effect as if proposal by the debtor in the meeting and be binding on the creditors mentioned in the repayment plan and the debtor. Where the adjudicating authority rejects the repayment plan under section 114, the debtor and the creditor shall be entitled to file an application for bankruptcy under chapter 4. A copy of the order passed by the adjudicating authority shall be provided to the board for the purpose of recording an entry in the register referred to in 196. If you see all the orders, after passing all the orders, the adjudicating authority is giving a copy to the board. So once the repayment plan is approved by the adjudicating authority, what will happen? A discharge order will come. On the basis of the repayment plan, the RP shall apply to the adjudicating authority for the discharge order in relation of the debts mentioned in the repayment plan, and the adjudicating authority may pass such discharge orders. So what happens is if it is something like one-time settlement. He has given a repayment plan saying that out of so and so amount, I will repay so much amount, so and so. That was approved. So finally, what happened? To the extent the repayment plan has been, to the extent the amount has been striked off, the amount will be discharged. The liability of debts becomes discharged. The repayment plan may provide for early discharge or discharge on complete implementation of the repayment plan. Suppose the repayment plan goes for a period, then it will say discharge on complete implementation of the repayment plan. So it will provide for immediate discharge or on complete implementation of repayment plan. So that's how the discharge order will come. Based on the repayment plan, the debtor has to make the payments under so and so way, and that is how the implementation will happen. Once this is done, the discharge order, the discharge will happen. The discharge order shall be forwarded to the board for the purpose of recording. Premature repayment plan coming to end prematurely. Here what happens is, before the plan itself has happened, it is prematurely coming to an end. When it happens, the repayment plan shall be deemed to have come to an end prematurely if it has not fully implemented in respect of all persons bonded by it within the period as mentioned in the repayment plan. Suppose it was specified in the period it has to be implemented, it didn't go implemented. Then, where the repayment plan comes to end prematurity, the RP shall submit the report to the adjudicating authority, shall state the receipts and payments made in pursuance of the repayment plan, the reasons for premature end of the repayment plan, and the details of the creditors whose claim has not been fully satisfied. So what has happened is debtor has satisfied the repayment plan in half, and half he is not able to comply. So what he said is, I'll pay in 4 installments. Probably he paid 2 installments and 2 installments are still not paid. So what are the receipts and payments in pursuance of the repayment plan, reasons for premature end, and details of the creditors who are still not satisfied. Now what will happen? The adjudicating authority shall pass an order basis of the report submitted to the RP that the repayment plan has not been completely implemented. The debtor or the creditor whose claims under repayment plan has not been fully satisfied shall be entitled to apply for bankruptcy order under chapter 4. So now what will happen is, since it has come prematurely, it has come to an end. Now the debtor and creditor can proceed under chapter 4 to the extent of the amount has not been satisfied. So this is with respect to personal insolvency. Now let us have a comparison of personal insolvency with corporate insolvency. Points of differences: personal insolvency and corporate insolvency. Application by creditors. Now here in the corporate insolvency, creditors are classified into operational and financial. Here under personal insolvency, no classification with respect to creditors, operational or financial. They are only one type of creditors. Then admission or rejection of application. In the case of corporate insolvency, adjudicating authority decides the matter independently. After admission, IRP is appointed. Whereas here in the case of personal insolvency, adjudicating authority decides the matter based on the report of the RP. So that is the difference here. First, before the adjudicating authority accepts the application, RP is appointed and then he forms an opinion and submits the report. Based on that report, the order is processed. So basically, part of the job of the adjudicating authority is delegated to the RP here. This was there under fresh start process. This is also there under personal insolvency. Then withdrawal of application, yes, in both the cases it requires 90% of the COC. Okay, COC, yeah, in the case of corporate insolvency, COC is mandatory and it shall constitute of only financial creditors. Only when there are no financial creditors, it is 18 plus 1 plus 1. 18 operational creditors plus 1 employee representative, I think 1 wages representative will be there. Whereas in the case of personal insolvency, there is no concept of COC, then the list of creditors, general list of meeting of the creditors is formed. Moratorium, yes, both the cases moratorium is there, but interim moratorium is not there under corporate insolvency, it is there under personal insolvency. Now coming to secured versus unsecured creditors, enforcement of security interest. Under corporate insolvency, no difference between secured and unsecured so far as the consideration of resolution plan is considered. Whereas under personal insolvency, secured creditor may opt for enforcing security interest or accept repayments as part of the prepayment. So there are two options. Whereas this option is there in the case of liquidation under corporate insolvency under part 2. Whereas here it is there under insolvency resolution process. The secured creditor can relinquish the right or can enforce the security. That is what was there under liquidation. Whereas here the secured creditor under personal insolvency has both the options here itself. Either he can relinquish his right and become part of the meeting of creditor, or he can enforce the security interest. Approval of the plan requires 66%. And here it requires 3/4, that is 75%. Rejection of the plan. In the case of corporate insolvency, it goes for a compulsory liquidation. Here, again, an application for bankruptcy has to be filed. Implementation and supervision of repayment plan. In the case of corporate insolvency provisional resolution plan itself provides for the mechanism for its implementation and supervision. I have told in the case of CRP, the resolution applicant, when he submits a resolution plan, he will provide what is the mechanism. Whereas in the case of personal insolvency, RP appointed under section 97 and 98 shall supervise the implementation of the repayment. Now coming to chapter 4, bankruptcy order for individuals and partnerships. So when will this, when will this come into place? When will the bankruptcy be invoked? Obviously, bankruptcy will be invoked if the insolvency resolution process fails, either initially or prematurely or at the time of RP stage itself. RP himself says it cannot be accepted. So that way. So if it ends, then it goes to the bankruptcy process. So basically, if you see here, what the code is trying to do is, it is trying to put the bankruptcy process as the last resort. And it is trying to ensure that some resolution or some repayment plan comes from the debtor and that is implemented acceptable so that they can move in. That is what we see. Banks, what do? They do something called as OTS, one-time settlement. What is this called? This is something called something else of the repayment plan. That is how in lines with that. Okay. Now coming to the bankruptcy order, chapter 4. Under the IBC code, sections 121 to 148. And now again we have one rule and one regulation. Rule is again application to adjudicating authority for bankruptcy process for personal guarantors, and one regulation for bankruptcy process for personal guarantors. Similarly, in line what we have seen for individual insolvency process, one rule, one regulation. One rule for application to adjudicating authority, one regulation for insolvency resolution process for personal guarantors to corporate debtor. These are one rule, one regulations. Okay. So these rules and regulations are only with respect to personal guarantors, what we have seen in the first case. Because for an individual or a partnership firm other than personal guarantors, it is not yet notified. So the rule and regulation is only for personal guarantors. So that is the reason sometimes what happens is the rule or the regulation might say guarantors, whereas the code will say debtors. Code is because code is trying to cover not just the guarantors, it is trying to cover everyone. So it will not say guarantors, but whereas the rules and regulations will say guarantors. So we have to understand that the guarantors referred is nothing but called as debtors. Okay. Now coming for the definitions. Section 79, subsection 3. Bankrupt means a debtor who has been adjudicated as bankrupt by the bankruptcy order under section 126. Each of the partners of the firm where the bankruptcy order under section 126 has been made against the firm. So who is a bankrupt? A debtor who is adjudicated bankrupt as the bankrupt, okay, under 126, or each of the partners. So in case if it is a partnership firm, each of the partners of the firm where the bankruptcy order is against the firm, that is the bankrupt. Second part of the bankrupt is any person adjudged as an undischarged insolvent. Who is a person who is adjudged as undischarged insolvent? So undischarged insolvent means court has passed the orders on so and so, and for that orders to be fully applied, it takes some time. In between this time, it is called as undischarged insolvent. Like for example, Mr. A is adjudged as insolvent on December 12, 2019. So on December 12, 2019, the court has passed the order, and the date directed by court for settlement of liability is January 1st, 2001. So December 12 to January 1st, there is some time. Now Mr. A shall be called as undischarged insolvent for the period of December 12 to January 1st. And once the liability is settled, he will be called as discharged insolvent. So in this period, he will be called as undischarged insolvent. 79.4. Bankruptcy means the state of being bankrupt. Bankruptcy debt. So we have seen qualifying debt, excluded debt. Now we are seeing what is called as bankruptcy debt. Bankruptcy debt in relation to the bankrupt means any debt owned by him as on the bankruptcy commencement date. Any debt owned by him. Any debt for which he may become liable after bankruptcy commencement date, but before his discharge by reasons of any transaction entered into before the bankruptcy commencement date. So the debt which he becomes liable after the bankruptcy commencement date, but before his discharge. So there is a period from the bankruptcy commencement date and discharge. There is a period. So there are some transaction which was entered into before the bankruptcy commencement date, but which are quantified after the date of bankruptcy commencement date by reason of any transactions entered into before the bankruptcy commencement date. This will also form part of bankruptcy debt. Any interest which is a part of the debt under section 171. Bankruptcy commencement date. Bankruptcy commencement date means the date on which the bankruptcy order is passed by the adjudicating authority under section 126. So here it is the date when the order is passed by the bankruptcy adjudicating authority, that will be called as bankruptcy commencement date. In CRP, we call it as CRP commencement date. Okay, here it is called as BCD, bankruptcy commencement date. Bankruptcy order means order passed by the adjudicating authority under 126. Bankruptcy process means the process against the debtor under chapter 4 and 5 of this part. Bankruptcy trustee means the insolvency professional who is appointed as a trustee for the estate of the bankrupt under 125. See, under CRP, a resolution professional has 3 stages. The first stage is interim resolution professional stage, which is for 30 days. Then there is a resolution professional stage, which is for the balance period of the CRP. And then the third stage is of a liquidator. Here there are only two stages, resolution professional stage and the bankruptcy trustee stage. In the case of insolvency resolution process, that time he was called as a resolution professional. And now the same person or different person, RP. In the case of after the bankruptcy commencement date, the RP will be called as, instead of calling him as a resolution professional, he is called as a bankruptcy trustee. So means the insolvency professional appointed as a trustee for the estate of the bankrupt under section 125. Now this is the chart which the process will go. Application for bankruptcy order. As you know, again an application has to be made by the bankruptcy order. As soon as an application is made, interim moratorium happens. So now this interim moratorium we have seen in three stages. For a start process stage, interim moratorium happens. Insolvency resolution process, interim moratorium happens. And here also application for bankruptcy order, immediately as soon as the application is made, interim moratorium is applied. Then nomination of a bankruptcy trustees. So immediately there we have seen RP is appointed. Here immediately a bankruptcy trustee is nominated. So now what will it, within 14 days, the bankruptcy trustee is nominated. He has to submit a report, and again the bankruptcy order by the adjudicating authority is passed. So that is called as the bankruptcy commencement date. Now once the bankruptcy commencement date happens, within 10 days, okay, what will happen? The adjudicating authority will again issue a notice in Form D or a public notice, because already the list of creditors is already there, because the insolvency resolution process is failed. So to the existing people, straight away notices will be issued. Apart from that, a public notice will also be issued by the adjudicating authority in Form C. So individual notice in Form D and a public notice in Form C will be issued by the adjudicating authority. Bankrupt to submit financial position to the bankruptcy trustee if the application was filed by the creditor within 7 days in Form B. So bankrupt will submit his statement of financial position to the bankruptcy trustee if the application was filed by the creditor. What happens if the application is filed by the bankrupt himself? He himself, along with the application, he is going to submit the statement of financial position. So once the notice is issued in Form D and Form C, what will happen? Again, the claims will come. So within 7 days, creditors to register claims with the bankruptcy trustee in Form 7. So now if we see, again the same process, public notice is given, creditors will submit the claims within 7 days in Form F. What will the bankruptcy trustee do? Bankruptcy trustee will again prepare the list of creditors. So within 14 days of the bankruptcy commencement date, he will prepare the list of creditors by the trustee. Now, then what will he do? He will summon the meeting of creditors. Within 20 days of the bankruptcy commencement date, he will summon the meeting of creditors. Complete the administration and distribution of the estate of the bankrupt. So what is the bankruptcy going to do? He is going to sell off the assets, set off with the liabilities, and he is going to administer the estate. So because the estate, he becomes the trustee of the estate. The bankruptcy trustees, all the assets comes into the bankruptcy trustee. He is going to administer the assets. So he is going to run, then sell and distribute it to the estate of the bankrupt. Then report of the administration by the trustee and to be presented to the meeting of creditors. Approval of the trustee's report by the creditors committee and determination of whether bankruptcy trustee shall be released. So that report he will put into the bankruptcy with the creditors and determination of whether the bankruptcy trustee can, and finally the bankruptcy trustee shall be released. So this is the process. Application for bankrupt. So again, as we have said, again an application has to be done. One, the application for bankruptcy shall be made by the creditor individually or jointly with other creditors or by the debtor. So debtor can make and the creditors can make individually or jointly with other creditors. Under CRB, Section 7 application can be filed by the financial creditor along with other creditors, whereas for the Section 9 application, the operational creditor cannot file an application with other creditors. So here also the creditor can file the application with other creditors, the debtor will file himself to the adjudicating authority, namely where the order has been passed by the adjudicating authority under Section 10(4). RP application rejects as it is for defrauding. RP himself has rejected the application because initially, as I have said, the first stage is RP approves. So he has rejected because it is for defrauding the creditors under section 104. Then section 115(2), adjudicating authority rejects the repayment plan, or 118(3), premature end. Initially, the repayment plan was approved, but subsequently, the debtor has not paid all the creditors and it has ended prematurely. So, under these three circumstances, the bankruptcy can be invoked. The application for bankruptcy shall be filed within the 3 months from the date of order passed by the adjudicating authority. So, it has to be filed within 3 months. So, under section 10(4), 115(2), 118(3), the adjudicating authority has passed the order. From there, 3 months, the application has to be filed. Where the debtor is a firm, the application may be filed by its partners. So where the debtor is a firm, the application can be filed by the partners. Initiation of application. Again, we have these two sections, 122 and 123. Filed by the debtor or guarantor. So under 112, the application will be filed by the debtor. If you refer to the rules, he will be called as a guarantor because the rules are presently applicable only for the guarantors. If you see the section, it will be debtor there. In Form A, fees is rupees 2,000. Debtor is a firm, the application can be filed with the partners. For the creditors can be filed by the creditors in Form B, fees is 2,000. Along with that, we have to refer to the application to adjudicating authority bankruptcy process for personal guarantor rules. Now coming to the sections 122 and 123. The application for bankruptcy by the debtor shall be accompanied by. So now here the debtor himself is filing a record of the insolvency resolution process undertaken, the statement of affairs of the debtor in such form and manner as may be prescribed as on the date of application for bankruptcy. So since the debtor himself is filing, he knows the state of affairs. So he is submitting the statement of affairs. A copy of the order passed by the adjudicating authority. The debtor may propose the IP as a bankruptcy trustee. Then application for bankruptcy by the debtor shall not be withdrawn without the leave of adjudicating authority. Once filed, it cannot be just withdrawn unless until the adjudicating authority allows it. The application for bankruptcy in case of deceased partner may be filed against the legal heirs. If suppose the debtor is deceased, in that case, the application will proceed against the legal heirs. Now application by the creditor. So earlier we have seen 122, which is by the debtor, and 123 is by the creditor. The application for bankruptcy by the creditor shall be accompanied by a record of the insolvency resolution process, a copy of the order passed by the adjudicating authority permitting the creditor to apply for bankruptcy, details of the debts owned by the debtor to the creditor as on the date of application of bankruptcy, and such other information which will be required. If you see here, statement of affairs is not coming into place here because statement of affairs, they don't have the creditors. The creditors may propose an IP as a bankruptcy trustee. An application for bankruptcy by the debtor shall not be withdrawn without the leave of adjudicating authority. Now, secured creditors, the secured creditor shall be accompanied with. Now, if I am a secured creditor, the statement by the creditor having a right to enforce the security that he shall, in the event the bankruptcy order being made, give up his security for the benefit of all the creditors of the bankrupt, or a statement by the creditor stating that the application for bankruptcy is only to the extent of the unsecured part of the debt and the estimated value of the unsecured part of the debt. Now, if you see right from the definitions we have seen, in the qualifying debt, the secured debt was not included. So since the secured debt is not part of the qualifying debt, here also the secured creditor, first of all, he can straight away sell his asset and take the amount. But if he doesn't want to sell the asset, he wants to give away his right or give away his charge. In that case, he can give away, become unsecured amount, make the entire amount of unsecured, and then he can file the application. Or he can file the application to the extent the amount is unsecured. That is what it is saying. But for the secured portion, he cannot make an application. Okay. Then in the case of secured and unsecured part of the debt shall be treated as separate debt. That is what. Suppose some amount is secured, some amount is unsecured. Both will be treated as separate debts, and he can make an application only for unsecured amount. Effect of application. What will happen once the application is made? Immediately interim moratorium comes into place. Now this is the third time we are seeing interim moratorium, fresh start process, insolvency resolution process, and the bankruptcy process. The interim moratorium shall commence on the date of making an application. Moratorium shall cease to have effect on the bankruptcy commencement date. So subsequently, once the bankruptcy order is passed, final bankruptcy order is passed, that day the interim moratorium shall cease to have effect. Where the application has been made in relation to the firm, the interim moratorium shall operate against all the partners of the firm. So where it is against the firm, it will operate against all the partners of the firm, because for a partnership firm, the partner and the partnership firm is one and the same, and the liability is unlimited. So hence, if it is against the firm, the moratorium is also applicable for the individual partners. Now, appointment of IP as a bankruptcy trustee. Now, there are many times we have seen this data 7,10. The insolvency resolution process as the bankruptcy trustee. Application is made. The adjudicating authority shall give a direction to the board for 7 days, and the board shall appoint a RP or the ARP confirming the name which is proposed by the debtor or the creditor, or they may appoint other person. So that is 7,10, same provisions coming again and again. Okay. So same thing. If the name is already proposed, what will the adjudicating authority will see? Whether the adjudicating authority will ask the board whether no disciplinary proceedings are pending. Then the board will confirm. If there is no name proposed, the adjudicating authority will ask the board to give a name or nominate a person, and then the board will give. Generally, the board doesn't give each and every name. What happens is, in the case of CRP, they ask for expression of interest from the RPs, and that list is given to the adjudicating authority, and the adjudicating authority. So in that list, they already have checked whether any disciplinary proceedings are there. So that way, the list is already given to the adjudicating authority, and the adjudicating authority generally checks from the list. It is not that each and every case they goes to the board. Board over a period keeps passing on the list to the adjudicating authority. Every 6 months, they take the list and gives the list to the adjudicating authority. Now coming to the final bankruptcy order, the adjudicating authority shall pass a bankruptcy order within 14 days of receiving the confirmation or nomination of the bankruptcy trustee under 125. The adjudicating authority shall provide the following documents to the bankrupt, creditors, and the bankruptcy trustee within 7 days of passing the bankruptcy order, namely the copy of application for bankruptcy and the copy of bankruptcy order. The bankruptcy order passed by the adjudicating authority shall continue to have effect till the debtor is discharged under 138. So this bankruptcy order will continue to have effect till the debtor is discharged under section 138. Now coming to section 128, on the passing of the bankruptcy order, the estate of the bankrupt shall vest with the bankruptcy trustee. So the estate of the bankrupt shall now come in the hands of the bankruptcy trustee. The estate of the bankrupt shall be divided among its, and the estate of the bankrupt shall be divided among the creditors. Now, subject to the secured creditors, the creditors of the bankrupt indebted in respect of the debt claimed as a bankrupt shall not initiate any action against the property of the bankrupt in respect of such debt, or commence any suit or legal proceedings, except with the leave of the adjudicating authority as such terms and conditions as may be imposed. That means, again, this is part of something called as a moratorium. Shall not initiate any actions against the property of the debtor. The bankruptcy order shall not affect the right of the secured creditor. He has not given up the security under section 1. So the bankruptcy order shall not have effect on the secured creditors. Secured creditors can take over his assets and recover the amount. Now, on passing of the bankruptcy order, the secured creditor shall not be entitled to any interest in respect of his debt after the bankruptcy commencement date if he does not take any actions to realize the security within 30 days from the said date. Now, bankruptcy commencement date has happened, and within 30 days, the secured creditor is supposed to realize the asset and take over the amount. Suppose what happens is he waits for some 120 days, 4 months, 5 months, 6 months, and finally he says on the bankruptcy commencement date, I have so much of interest. Not possible. Within 30 days, he is supposed to realize the amount. So yes, suppose if it is within 30 days, yes, he can charge, because it says shall not be entitled to any interest in respect of debt after the bankruptcy date if he does not take any action. But if he takes action to realize the asset within 30 days, yes, he can take the interest for 30 days. Order against firm. where the bankruptcy order under section 126 has been passed against the firm, the order shall operate as if it was a bankruptcy order against each of the individuals who on the date of order is a partner. So if it is against the firm, it is deemed to be as if it is against each individual. Now coming to statement of financial position, where the bankruptcy application filed by a creditor under section 123, the bankrupt shall submit. So where the application is filed by the creditor, the bankruptcy trustee is not having the statement of financial position. So the bankrupt shall submit the statement of financial position to the bankruptcy trustee within 7 days from the bankruptcy commencement date. Where the bankruptcy is a firm, the partners as on the date of order shall submit a joint statement of financial position of the firm, and each of the partners of the firm shall submit the statement of financial position. So a joint statement of financial position of the firm and each of the partners has to be submitted. The bankruptcy trustee may require the bankrupt or any other person to submit in writing further information explaining or modifying any matters containing in the matters of the financial position. So bankruptcy trustee can call for additional information. The adjudicating authority shall send notice within 10 days of the bankruptcy commencement date to the creditors in statement of financial position submitted by the bankrupt under section 139. The application for bankruptcy submitted by the bankruptcy under section 122 and issue public notice inviting claims from creditors. So what is the adjudicating authority is doing here? Shall within 10 days of the bankruptcy commencement date to the creditors mentioned. Now there are two set of creditors. One set of creditors whose names are mentioned in the statement of affairs submitted by the bankrupt under section 129 or application by the bankrupt submitted by the bankrupt under section 122. So if the names are already there or the application is made by the bankrupt submitting the bankruptcy application 122, will send the notices to these people, and to others it will issue a public notice. So that means for these people individual notices will be sent, and for the others a public announcement will be made. Okay, so individual notices will be given to whom? The names whose names are appearing in the statement of affairs and where the application is made by the bankrupt, by the application by bankrupt submitted by the bankrupt under section 152. Because there the statement of affairs is submitted under section 122, where the bankrupt himself is filing the application. Now, once the public notice is given, the public notice shall include what? The last date up to which the claim shall be submitted and shall be published in the leading newspapers, one English, one vernacular language, where the bankruptcy trustee resides, affixed on the premises of the adjudicating authority, placed on the website of the adjudicating authority. If you see, the contents more or less are same what we have seen in the notice in the insolvency resolution process. Now, conducting the meeting of creditors. Registration of claims. The creditor shall register the claims with the bankruptcy trustee within 7 days of the publication of public notice. So once the public notice is given, he is going to submit the claims within 7 days. Now, preparation of list of creditors. The bankruptcy trustee shall within 14 days from the bankruptcy commencement date prepare a list of creditors of the bankrupt on the basis of statement of affairs and the claims received. Summoning the meeting of creditors. The bankruptcy trustee shall within 21 days from the bankruptcy commencement date issue a notice for calling up the meeting of creditors. The notice shall state the date of meeting, which shall not be later than 21 days from the bankruptcy commencement date. So what is he doing? Bankruptcy trustee is collecting the claim forms, and then he has prepared the list of creditors, and then he has convened the meeting of creditors. Conducting the meeting of creditors. The bankruptcy trustee shall convene the meeting, decide the quorum, and conduct the meeting only if the quorum is present. The following business shall be conducted: to establish the establishment of the committee of creditors, any other business that the bankruptcy trustee deems fit. These will be the agenda items. Then the bankruptcy trustee shall not adjourn the meeting of the creditors for the purpose for more than 7 days at a time. So they cannot adjourn the meeting for more than 7 days. Voting rights of creditors. Every creditor is assigned a voting share. The creditor shall not be entitled to vote in respect of a debt for unliquidated amount. So as again, the amount shall be liquidated amount and not unliquidated amount. The following creditors shall not be entitled to vote: creditors who are not mentioned in the list of creditors and who have not given a notice and who have not been given a notice by the bankruptcy trustee, creditors who are associated of the bankrupt. So the creditors whose names are not being mentioned in the list of creditors, and those who have not been given a notice by the bankruptcy trustee, and the creditors who are associated. So if you see here, associates were earlier excluded in the insolvency resolution process also, and the associates are also excluded in the bankruptcy trustee also. In fact, in the CRP process also, in the list, in the committee of creditors, the related person cannot be, will not be entitled, was not entitled to vote. So, discharge order, the bankruptcy trustee shall apply to adjudicating. The bankruptcy trustee shall apply to point the. In the CIRP also, the related party cannot become a part of the COC member. Yes, the related person cannot be a part of the COC member. Only suspended directors and the financial creditors. Now, the bankruptcy trustee shall apply to the adjudicating authority for a discharge order on the expiry of 1 year from the bankruptcy commencement date. So the period of discharge 1 year is given from the bankruptcy commencement date, or within 7 days from the approval of the COC under 137 prior to expiry of 1 year. So the maximum period given for the bankruptcy trustee for discharge is 1 year, or the COC can get it done before the expiry of 1 year. The adjudicating authority shall pass a discharge order on an application by the bankruptcy trustee. The copy of the discharge order shall be provided to the board for the purpose of recording an entry. Disqualifications of bankrupt. The bankrupt shall, from the bankruptcy commencement date, is subject to the following disqualifications: being appointed or acting as a trustee or representative in respect of the trust, estate, or settlement, be appointed as acting as a public servant, be elected as a public officer, and sitting as voting member of a local authority. See, already the bankrupt he's facing the bankruptcy. Now, in such cases, he is not entitled to hold such positions. Disqualifications shall cease to have effect if the bankruptcy order is modified or recalled, or he is discharged under section 138. So till the discharge happens, he cannot be under so-and-so positions. Restrictions on bankrupt. So here again, certain restrictions are there. He cannot act as a director and take part as a promoter, formation, or management of a company. He is prohibited from creating charge. He has to inform other partners. He has to inform all the parties that he is going insolvency bankruptcy process. He's be incompetent to maintain any legal action and should not travel overseas. Similar conditions we have also seen in the case of the insolvency resolution process also. Fees of the bankruptcy trustee. The bankruptcy trustee shall charge such fees as may be specified in the proportion to the value of the estate of the bankrupt. The fees shall be paid from the distribution of the estate of the bankrupt in the manner provided in section 178. Now coming to chapter 5, administration and distribution of the estate of the bankrupt. Now here, if we have seen, why did they first of all break the bankruptcy parts into two parts? Chapter 4 and chapter 5. Chapter 4 talks about how the application has to be filed, how the meeting of creditors has to be conveyed, and finally how the order of the adjudicating authority will be filed, and finally how the discharge will happen. But how the bankruptcy trustee will administer, how will he distribute, and what are the preferential transactions, undervalued transactions, and extraordinary trade transactions, how they will be taken into care, how they will be administered, is all provided in the chapter 5. So this is administration and distribution of the estate of the bankrupt. How the bankruptcy trustee is going to administer and distribute the estate of the bankrupt. This is all the procedure requirements will be covered under section 149 to 178. 149. The bankruptcy trustee shall perform the following functions in accordance with the provisions of this chapter: investigate the affairs of the bankrupt, realize the estate of the bankrupt, and distribute. So what is he doing? Investigate the affairs of the bankrupt, realizing the estate of the bankrupt, distributing the estate of the bankrupt. Now, duties of the bankrupt towards bankruptcy trustee. The bankrupt shall assist the bankruptcy trustee in carrying on the functions, giving the information, attending to the bankruptcy trustee at such times required, Giving notice to the bankruptcy trustee of any event which has occurred after the bankruptcy commencement date. If he has acquired any property, devolved any property, increase in the income, or any other things as may be prescribed, he has to provide additional income. So these are the duties of the bankrupt towards the bankruptcy trustee. The bankrupt shall give notice of the increase in income or acquisition or dissolution of the property within 7 days of such increase, acquisition, or devolution. We have seen acquisition, devolution, and increase. He has to inform the bankruptcy trustee within 7 days. Now, there are certain approval of creditors for certain acts. Now, the bankruptcy trustee cannot on himself decide on everything. He has to take the approval of the creditors on these points. What are those? Carrying on the business of the bankrupt, initiate or defend legal proceedings against debtor, accept sale consideration at a future time, mortgage or sell any properties for raising money for repayment of debt of the bankrupt, arbitration or compromise with respect to subsisting debts, any compromise or arrangement as may be considered expedient, making payment or incur liabilities with a view to obtaining for the benefit of creditors rights attached to an asset, and appointment of bankrupt to supervise the management of the estate, carry on the business, assist the trustees. So these are acts which explanatory approval of the creditors are required. So the bankruptcy trustee has to take the approval of the creditors. Vesting the rights of the bankrupt in the bankruptcy trustee. The estate of the bankrupt shall be vested in the bankruptcy trustee immediately after the date of appointment. The vesting shall take effect without any conveyance, assignment, or transfer. Now, what happens is immediately on passing of the order, the estate will come to the bankruptcy trustee. No assignment, transfer, conveyance is required. The estate of the bankrupt shall include all properties belonging to or vested with the bankrupt at the bankruptcy commencement date, the capacity to exercise and to initiate proceedings for exercising all such powers in or over in respect of the properties as may be exercised by the bankrupt for his own benefit at the bankruptcy commencement date or for the benefit of discharge order passed under 138. All properties which by the virtue of the provisions of this chapter is comprised in this estate. So these are the items which will include in the estate of the bankruptcy commencement date. All properties, capacity to exercise or initiate proceedings, and all properties by virtue of the provisions of this chapter. The estate shall not include excluded assets. As we have seen, starting from what are the excluded assets? Personal ornaments, life insurance policies, dwelling house, one dwelling house up to 20 lakhs in a urban, rural 20 lakhs and 10 lakhs. So those limits, what we have seen, they are all excluded assets. It will not exclude, will not be included. Property held by the bankrupt on trust for any other person, all sums due to any workman and employee from the provident fund, the pension fund, and the gratuity fund. Such other assets as may be notified by the central government in consultation with the financial service sector regulator. So these will be excluded assets or will not be included in the bankruptcy trustee. Restriction on disposal of the property. Any disposal of the property made by the debtor during the period between the date of filing the application for the bankruptcy trustee and the bankruptcy commencement date shall be void. So that means from the date the application is filed till the date the bankruptcy commencement date shall be void. Even if it is received such property before the bankruptcy commencement date in good faith for value and without notice of filing the application for the bankruptcy. So what is this period? It is first thing is it is made by the debtor. The period is from the date of filing the application for bankruptcy and the bankruptcy commencement date. So because once the bankruptcy commencement date has happened, the estate comes in the hands of the bankruptcy trustee. But between this period, when the application is filed and the bankruptcy commencement date, if any transfer has happened, that will be void, even if it is in good faith for value and without notice of filing the application for bankruptcy. After acquired property of the bankrupt, the bankruptcy trustee shall be entitled to claim the estate of the bankrupt only after acquired property by giving a notice to the bankrupt. So what happens is if the bankruptcy trustee, any after acquired property, what happens is suppose after the bankruptcy commencement date, the bankruptcy trustee, the bankrupt has acquired some other property, then that also can be taken by giving a notice to the bankrupt. The notice shall not be served in respect of excluded assets or any property which is required by or devolves upon the bankruptcy after a discharge order is passed under section 1. So once the discharge order is passed under 138, then if he acquires any property, then he can take, and property shall not include excluded assets. So these are the two exceptions. Notice shall be given within 15 days from the date on which the acquisition or devolution of the after acquired property comes to the knowledge of the bankruptcy trustee. So within 15 days, the bankruptcy trustee has
Sorry,
to give the
interrupting Ritesh.
Yes, Mr.
You need further 10-15 minutes?
I'll just a moment.
Because curfew is there, people are asking about
7:50. Na? See, I'll tell you the number of slides more are.
Otherwise, you can take only important slides.
Yeah, that I do.
Yeah, please.
That way. So I'll do one thing. I'll try to complete in the next 15 minutes. Okay. Done. So anyway, the presentation is there and the process is more or less known. So now we're coming to onerous property. So onerous properties are those properties which are not profitable and which doesn't get any value. So onerous property, the bankruptcy trustee, by giving a notice, can disown such properties. Now, vulnerable transactions, these are in lines with what we have seen under CRP, also undervalue transactions, preferential transactions, and extortionate transactions. These are the transactions which have been entered within a period of 2 years, ending on the date of filing of the bank application for bankruptcy. From the date of application for filing, go back 2 years and check whether such undervalued transactions, preferential transactions, or extracted transactions are there. If they are there, the bankruptcy trustee will file an application to a adjudicating authority, and the adjudicating authority will make them void or declare them void. So this is with respect to. So, and even if the bankruptcy trustee dies, even if the bankrupt dies, the bankruptcy proceeding shall continue as if he is alive. Okay. Now this is priority of the payments. How the payments will be made, the waterfall model. Okay. This is, you can compare them with section 53 of the CRP process and how it is going. Suppose out of the payment, first payment will go to the bankruptcy trustee, then workmen and secured creditors, then the employee dues, then the government dues, and then other debts. This is how the waterfall model will be there. These are the key differences between insolvency resolution process and bankruptcy process. Okay, just to have a quick recap. And then we have the adjudicating authorities. Who are the adjudicating authorities? The adjudicating authorities are the debt recovery tribunals, and no court or no civil court authority shall have the jurisdiction. If in case there has to be an appeal, the appeal has to be filed within 30 days and will go to the debt recovery appellate tribunal. Okay. Then the final appeal will be with Supreme Court, and that has to be made within 45 days. Expeditious disposal of applications, where the application is not disposed of, the order is not passed within the specified period, the DRT or the DRT, as the case may be, shall record the reasons for not doing so, and the chairman of the debt recovery tribunal take into account such reason extent. So these are for faster proceedings. Now coming to the penalties. Penalties, what I have done is I have prepared a table. So under 184 to 187, what are the penalties? 184, debtor or creditor provides false information. So the penalty will be 1 year or up to 5 years, 5 lakhs. So 1 year is a jail term and 5 lakhs is the penalty. So with monetary and jail terms. So this is how for both. So creditors in favor, creditor votes in favor of the RP dishonestly. So up to 2 years, up to 3 times. And if the amount is not quantifiable, then 5 lakhs or both. IP deliberately contravenes. So IP also has contravened. In that case, up to 6 months jail term for him also, and 1 to 5 lakhs or both. Bankrupt fraudulently misapplied, retained or accounted, up to 3 years, 3 times, not quantifiable, 5 years. Bankrupt knowingly makes false representation and 122, then up to 6 months or up to 5 lakhs or both. Bankrupt failed to provide or held the books of accounts of financial information. Then bankrupt contravenes the restrictions of 140, 141. Bankrupt failed to deliver possession under 156. Then bankrupt fails to account for loss 12 months before filing the bankruptcy. Bankrupt absconds or attempts to abscond. Bankrupt fraudulently misapplied, retained, or else or accounted. See here, what might happen is they might ask a case law or a case study. Okay, so it might not be a simple case of straightaway section. They might make it as a case study, and what you can do is wherever possible, you can try to correlate them with the CRP penalties. Okay, the penalties which are there under part 2 and the penalties which are there under part 2, 3, and form a table and try to recollect. So this is how with this I come to the end of the session. Majority of the sections I have tried to cover, but yes, since the number of slides had already been increasing, what I have done is the regulations totally I have not covered, but you have to read the regulations. Like for example, who cannot be a resolution professional, who cannot be a bankruptcy trustee. Those are all given in the regulations. For example, I'll do something. So these are all the regulations which you can go through. I'll share in the WhatsApp group also. So this way, majority of the content I have tried to cover, and rest of I don't see the subject as very difficult. Only thing is it needs regular reading, and you have to note down the points and try to see that you are able to recollect one day before the exam. So this is what some of the key points which you have to remember. So I thank all of you for your patient listening. Thank Hyderabad branch for their giving the opportunity once again. Thank you one and all. Thank you.
Thank you, Ritesh. Thank you
Yeah,
so much.
thank you, Dhyaniva Sharma, the Central Council member for Hyderabad, for gracing the occasion. Thank you.
Yes, sir. Closing remarks, please.
No, I should be thanking Ritesh. I just want to get it on record for all the people. Ritesh is thanking the Hyderabad branch for giving him an opportunity, but I thank Ritesh for giving me an opportunity for the first time ever I spoke in institute was only on his suggestion long back. So thanks to you, Ritesh, for getting me introduced to the institute. I'll put it this way. And the most important part is the way your presentation was going through. I was just recollecting our old time of studying together and the way you used to put forward all the matter very clearly in one after another session. And I was very happy to know that, it is on a individual and a partnership firm. You will not believe I wanted to perceive bankruptcy IBC, but the only thing was I had other limitations to work on. But my presentation started from the individual and partnership only, which was way back and when the IBC was introduced. But one thing which I would like to, Ritesh, urge everyone on your behalf also is that, the insolvency is one course, this opportunity of chartered accountants, which is actually giving us a very good, visibility. Out of the 100%, more than 70% of the IB professionals are chartered accountants. And the number is very small. And the most important part is when the situations are coming in, whenever the new opportunity is coming, people are enterprising and taking certain, engagements, which I personally feel because the time constraint, huge time involvement is there, not constraint. And it is personal involvement of every chartered accountant who is an IB professional who has to give time individually, apart from the team which is going to use for his other benefit. But you have always been a person who has been a front runner in more than one race and ensured that people get into this, and the way you have always been deliberating, disseminating knowledge of your experience, what you have been doing, and excellent feedback which I get on your account also with regards to a true professional in IB practice. I think that is making a whole lot of difference to this. And it's actually a very good thing. And the moment the chairman called me up and he was talking about the IB, first question I asked him was, is Ritesh there in the presentation or not? Yeah, and he said, yes, he is there. Then I said, okay, then go ahead. So though I don't have authority to approve anything, but as a protocol, we generally discuss, it well. And your thoughts and the way someone has rightly written, nicely tabulated matter, which is actually going to be very beneficial for the members when they write their examination. And I compliment Hyderabad branch and particularly Macher for that matter, that he being a professional, he is actually getting involved and ensuring that refresher courses like this happen. And in certain cases, like, we wanted to take a central approval, but actually they have other protocols that need to be maintained. So we avoided that and we said, no, let knowledge disseminate. That's the best way of doing it. If we wait for certain things to come in, approval has to come in, it is again going to take a lot of time. So I compliment you also, Chairman, and the entire team for ensuring that it has been taken care. And more importantly, Naresh Bhai has always been a great support in the entire process of Hyderabad activities. And his contribution is basically ensuring that people come and be part of it. And he always ensures that he is also attending and listening to, and whenever the matter comes, he puts forward. So overall, in total, Ritesh, the last portion which I've heard was fantastic. And I was thinking, like, when I made the presentation, how it was and what was there. But a lot of changes have happened. And this practice is going to be a very good, he is a registration king, Naresh. Okay. So Naresh Bhai, public also knows that.
Naresh sir is our participant now. He's also one of the delegate. And he's real role now.
Hey, but Chairman, what happens is basically now this kind of knowledge dissemination, when person like Ritesh comes and talks, he talks more of a practical side of it. Though the theory part you cannot avoid, and he had put it in the presentation, but otherwise his experience, practical exposure, what is there, that ideas will be of a very good value to all our members, and that makes a whole lot of difference. So Ritesh, thanks to you for introducing me to the institute, and you should be, you thank institute, I don't have any problem, but let me thank you. That was the only thing. Great, and I think in the tax bar also you are doing excellent job. Continue doing it, bhai.
Thank you. Thank you, Naresh. Really.
And because you were there, I just came today. So thank you very much.
Nice of you. Thank you so much.
Thank you.
Actually, Ritesh, presentation was excellent and the flowchart was very interesting. I think that flowchart details was very good. So I thought, anyway, Chairman will circulate to all the members who are attending this program. That was something even I was trying to make notes, but since you already made, I think it's really good and we'll use that only.
No, everybody has to do it. See, for passing an examination, a tabulation is very much important. You should write section, regulation, and time frame. That's one of the key factors for passing the examination. Please do the charts and please do the tables so that you can easily crack the examination.
IBC exam is all of memory, I think. With the
Yeah.
Twisted bhi rehta, thoda twisted questions aayenge, so you should be careful.
Yeah, we are very much thankful and grateful for your time and efforts, Ritesh Bhai, and you are the one of the person who has guided me in designing this entire program, and you are the first person for clearing me my CPA doubts about IPA and IPA. Laser and myself tried to reach that, but that day we could not able to get that because that was a holiday. And immediately I contacted you. You has given very good clarity on IBA CPRs. Thank you so much for that. And one more doubt, Ritesh Bhai. Can we upload the CPRs for IBPI immediately or after this program? Because within 7 days we need to upload it.
See, now thing is, first of all, IBPI has recently come with the. See, till now what we were doing is we were uploading the CPE in the IBPI portal in the IP login. So what we were doing is I was downloading the CA certificate which was available in the CP portal. So normally CA Institutes calls for the uploading of the CP attendance within 3 days.
Yes.
So more or less on the 4th day you will find that certificate in the CP login. Download that certificate and then go to IBPI login. There it's a totally descriptive. So basically, as per the CP requirement of IBPI, any program which is done by a statutory authority, okay, is eligible. But what it does is the subject should be from IBC, and it also gives other subjects also. But other subjects, what I have observed is even if you upload straight away, they are being striked off. So what happens is there is a lot of striking which happens. So basically, your topic should match with the IBC and related topics. It can be on SurfAC, it can be on IBC, more or less on those lines. And then what the CP requirement says is, if it's a full day program, the maximum CP can be provided is 4 hours. So generally, if the institute conducts 6-hour program, they will provide 4 hours CP. If it's a half day program, the CP provided is 2 hours. So if we upload 3 hours, if the CA institute says 3 hours, they will approve it as 2 hours. So if we say 3 hours also, they will approve it as 2. And if it is a 2-hour program, they will approve it as 1 hour.
Yeah, that's what we made it.
A lot of striking happens. So it is always better to have more number of programs in our portal, so that finally we get that 20 number. I'll tell you what is the implication if you don't get that 20 number. In case if you don't do the CP requirement of ICI maximum, what ICI will do? They will record it in the MEF portal. But here, next year, your AFA will not be approved. So you cannot take any assignments. And if you take any assignments, immediately 13 days, you will get a show cause notice from the IBPI. So that is how grave implications are there of CP. Okay, so it is always we need always support of the branch to conduct more and more programs from the IP, because it is seen that the number of programs which are conducted by IBPI and as well as IIIPI are very few in number.
Yes, sir.
But suppose if I want to get 20 hours of CPE, that means effectively I should have 30 to 40 hours of program from IIIPI or IBPI, which is very few in number. In fact, there was a recent course which was done by IBPI. Within 2 days, it was full. So that is the practical problems which are coming for CP. And since last year was the first year for a CP requirement, and most of the AFA were renewed in the month of November and December, they have not considered. But next year we have to see how will they take it forward.
Thank you.
That's how the provision is.
Thank you, Ritesh.
Because I will share that CP requirement in the WhatsApp group also.
Yes, I shared the members, and as per your advice, I already and we are planning to organize more and more sessions in the coming couple of months, particularly not only for the CPE or examination purpose, for advanced course also, as yesterday's discussion. And thank you so much for your excellent presentation. And really, it speaks your confidence and command on the subject. And we are looking forward to your continued support for the Hyderabad branch. And once again, thank you so much. And as a token of thanks, we'd like to present a small virtual certificate of appreciation. Ritesh bhai, kindly request to accept, please.
Thank you.
I thank all the delegates for participating and encouraging us. We are very much thankful from the Hyderabad branch. Over to Secretary. Acting Secretary, sorry, Deepak bhai.
Thank you, Chairman, sir. With this, the day 2 of our IBC refresher program coming to an end. It was a very good learning session. Thank you, Ritesh sir, for taking your valuable time and addressing the members and taking all your efforts in preparing the presentation and the knowledge dissemination to the members. I hope your insight on part 3 of IBC code on individual and partnership has been very valuable to today's audience. I thank our Central Council member Dayaniva Sharma sir for his valuable words of wisdom, and Regional Council member Naresh Gilli sir for his presentation. I also thank all the delegates who have attended today on time and throughout the program. We'll see you tomorrow, same time on the day 3 program. By tomorrow, presentation will be taken by Srimati CA Anita ma'am from Chennai on liquidation. Till that time, request you to stay safe, stay indoor. Thank you.
Thank you.
Thank you. Thank you.
Thank you.
Thank you, Ritesh sir. Thank you, Daya sir. Thank you, Chairman sir.
Thank you.
Signing off.
Please. Thank you, Ritesh bhai. Thank you so much.